being bound by or cognizance who otherwise have business before this court be now here and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Good morning, everyone. Welcome to the third day of our spring oral argument session here in beautiful downtown Pittsburgh. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In 2022, we celebrated our court's historic 300th anniversary in Philadelphia. We on this court are very proud of our rich history. As you may have noticed when you entered the courtroom, our court has a tradition of hanging oil portraits of former Chief Justices in our courtroom space. Today, I'd just like to touch on some of the portraits here in our Pittsburgh courtroom, and I thank our court crier, Brian Minner, for taking an interest in our court's history and compiling these biographies, starting with the portrait hanging to my immediate left. Portrayed with glasses, Chief Justice Drew suffered from poor vision for most of his life. His doctors advised him to quit Columbia Law School because of the effect reading lengthy opinions had on his eyesight, but he was undeterred and he rose to the highest position in Pennsylvania's courts. Likely because of his poor eyesight, Chief Justice Drew limited the length of his opinions and joked that the legislature should charge judges for the printing cost of any opinions over 3 pages. To Drew's left is Chief Justice James Sterrett. He began his public service on the Allegheny County Common Pleas bench before his appointment to this court by Governor John Hartcraft. Justice Sterrett lost the following election, but ran again and won a seat on this bench. He became Chief Justice in 1893 and served until his retirement in 1900. To Sterrett's left is Chief Justice Robert Fraser. Fraser also served as an Allegheny County Common Pleas Court judge before his election to this court in 1915. He became Chief Justice in 1930 and served until his retirement in 1936 at the age of 86, with a legal career spanning 62 years, 40 of those serving as a judge. In 1961, Governor David L. Lawrence appointed Pennsylvania's Attorney General Ann X. Alpern to become this court's first female justice. However, in order to win a full term, she had to run for election, and she had to defeat Henry X. O'Brien, the next portrait, in the general election that same year. Alpern lost in a contentious election. During O'Brien's term on this court, he established the Lawyer-Client Security Fund to reimburse clients that were defrauded by their lawyer. O'Brien served as Chief Justice from 1980 to 1983. I'd like to give some brief instructions to counsel before we hear the first case. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their brief for any particular issues. In cases in which there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates there are particular issues we wish to explore further. I also remind you that we do not permit rebuttal. Finally, while we have no set time limit for argument in our court, I will advise counsel when the court is satisfied that all of its questions have been answered and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Commonwealth of Pennsylvania versus Ivory King, representing Ms. Caroline Heller, representing Commonwealth, Mr. John Fink.
In this discretionary appeal, Appellant was 17 years old when he shot and killed 4 people who were attending a Memorial Day party in 1998. Appellant pled guilty and was initially given 4 consecutive sentences of life without possibility of parole. But his sentence was vacated after the United Supreme Court held in Miller v. Alabama that categorical life sentences for juveniles violated the prohibition against cruel and unusual punishment in the Eighth Amendment to the United States Constitution because such categorical sentences fail to account for the prospect that a juvenile was capable of rehabilitation. On resentencing, the trial judge found that Appellant was capable of rehabilitation, but nevertheless imposed a new sentence of 20 years to life for each murder and ordered those sentences to run consecutively, resulting in Appellant receiving an aggregate sentence of 80 years to life. We are asked to address whether such a sentence constitutes cruel punishment under Article 1, Section 13 of the Pennsylvania Constitution, given the trial court's determination that Appellant was capable of rehabilitation, and whether, in making this determination, his sentences should be considered in the aggregate or separately. Additionally, we are asked to determine if such a sentence constitutes an as-applied violation of the Eighth Amendment to the United States Constitution. Good morning.
Good morning. Justices of the Supreme Court, Madam Chief Justice, may it please the Court, my name is Caroline Heller from the law firm Greenberg Traurig, and here today with me are my co-counsel, Marcia Levick from the Juvenile Law Center and Bradley Bridge from the Philadelphia Defender's Office.
Welcome.
Together, we are pro bono counsel to Appellant Ivory King. Just about a month ago, in Commonwealth v. Lee, this court held that the prohibition against cruel punishments in Section 13 of the Pennsylvania Constitution is broader than the cruel and unusual punishments provision in the Eighth Amendment of the United States Constitution. In doing so, this court did not define cruel punishments or provide an exhaustive list of what constitutes a cruel punishment. However, this court did find that Section 13 is founded on Enlightenment principles of reformation and deterrence, and that punishments that exceed penological justifications for punishment are considered cruel because they go beyond what is necessary to punish. The court also found that concepts of what is cruel or what is necessary may change over time based upon scientific advancements. In this case, based upon that holding, Ivory King's sentence is considered a cruel punishment because it goes beyond the penological justifications for punishing a child capable of change and rehabilitation. Several things. First, to hold that it is unconstitutional to punish a child capable of change and rehabilitation by imposing a sentence of actual life or a sentence that is so long that it is unlikely the child will ever live to see the parole board. Second, to find that in evaluating the constitutionality of sentences for a child capable of change and rehabilitation, if there's a consecutive sentence or a sentence that in the aggregate exceeds the life expectancy of the child, whereby the child will not get a chance to see the parole board, that is unconstitutional.
Problem. Oh, go ahead, Justice.
Here's my concern. My concern in Commonwealth versus Lee, we took the mens rea into play. The fact that a juvenile mind is not as matured until age 21. This case is not about mens rea or the intent. The defendant here killed 4 people. The question before this court is, could we aggregate those ranges? And if we're aggregating them, why should we treat a juvenile defendant who murdered 4 people at 17 and a half compared to an 18-year-old who could have killed 4 people? And his follow-up is, then how many people have to die before they could get a de facto life sentence?
So there are a couple of questions there. I'm going to try to take them in turn, and if I forget to get to one of them, please remind me. Let's talk about why this court should aggregate sentences for a juvenile who has been found guilty of several first-degree murders. There are a bunch of reasons. The first is that Section 13 is broader than the Eighth Amendment. So let's talk about what the Eighth Amendment guarantees first and what those Eighth Amendment cases found. In Miller and Graham, Montgomery, all those cases, the courts did not focus on the nature of the crime. They focused on the nature of the child and how all children are different than adults because they aren't as mature and because their brain is developing. The court didn't say that children's brains are developing solely if they commit one crime. They focused on the child, not the crimes. In fact, for example, in Roper, the court didn't say death penalty is unconstitutional only as to one murder, but if it's two, then you could have the death penalty for the second. And that's, again, they focused on the child. So in state court cases, so at the very least, the Eighth Amendment protecting children based upon their nature and not the nature of the crime, Section 13 has to be as protective. In fact, a lot of state court cases that have found that you have to aggregate when we're talking about child and extending Miller and those other cases agree. They say we're still dealing with a child, whether it's a child who's committed one murder or a child who's committed an extremely heinous series of crimes. It's necessary to aggregate because children, whatever the crime is, are capable of change. If they're capable of change and rehabilitation, it violates the Eighth Amendment to sentence them to a term of years.
Share with us how that correlates to what we are to consider as judges in the sentencing phase.
In the sentencing phase, courts would need to consider, and here the court did. It considered the fact that Ivory killed 4 people. In concluding, despite that, based upon all the expert evidence and evidence from DOC employees, he was still capable of change and rehabilitation. And under the Eighth Amendment, which is less broad than Section 13, it's a cruel and unusual punishment to sentence a child who is capable of change to a term of years where they will never see the parole board. Section 13 is broader than that. This court has made that determination. So what does that mean? That broadness has to have some meaning. In the case of children, whether it's one murder or 2 or many.
What if it's 50 murders? What if he's a serial killer? What if he killed a whole congregation? Under your theory, we have to view it all the same way we'd view one crime.
Well, yes, but here's the way a court would go about considering it. The first step is having the hearing to determine whether or not this is a juvenile capable of change and rehabilitation. At that point, the court may take into consideration the fact that it was 50 murders, and that fact alone may be enough, along with whatever testimony is presented, for a court to say, you know what, this child is not capable of rehabilitation.
You're saying it needs to be individualized.
Yes, I mean, each hearing would have
Process for each of these defendants, a process which takes Miller into account as well as all other factors on an individualized basis.
Yes, with the rule that if a court determines the child is capable of change and rehabilitation, it must set a sentence or impose sentences that in the aggregate allow the child to see a parole board. And that's actually the second.
Can I just briefly follow up on that?
Yes.
Just for a moment. Is there an analytical inconsistency, or is it just a interesting irony that you want categorical treatment, hearkening back to Justice Dougherty's observation about his age being 17 and a half at the time of these murders. You want a categorical line drawing consistent with SCOTUS jurisprudence at 18, but you would abhor any categorical treatment as far as sentencing. Is there any problem there?
I don't know that we're necessarily rejecting a categorical treatment at sentencing, because the categorical treatment at sentencing is courts, regardless of the nature of the crime, have to determine whether the child is capable of change and rehabilitation. So it's an individualized sentence, but that's the categorical rule. And Section 13, prohibiting cruel punishments, and consistent with the founding of Section 13 and why it was written that way, the categorical rule is that if at an individualized sentencing there's a determination the child is capable of change and rehabilitation, that child should have a sentence that allows them to see a parole board.
And what guidance should we, suppose you win, and what guidance are you asking us to provide sentencing courts on these resentencings, or prospectively on sentencings, as far as that parole eligibility, because what's the actuarial line you want us to draw as far as determining or decreeing what's a de facto life sentence?
So a few things. First, the court would have to take into consideration the Miller factors. I think that Section 13 would subsume the Miller factors. Then a court would have to make a determination whether or not the child is capable of change and rehabilitation, or whether it's that rare, if that child even exists, incorrigible child who is forever solidified in their criminal behavior and their manner of thinking. And then thirdly, to the nature of the sentence, what we proposed in the brief is that children should not get more than 35 years as a sentence, either individual in the aggregate. So the first chance that any child who is capable of change and rehabilitation should be able to see a parole board would be at 35 years. And that's consistent with states that have banned juvenile life sentences. I think there are 15 states that have banned juvenile life sentences. And this is all in our brief also, so I don't have the cites off the top of my head. I don't know that the statutes address whether it's in the aggregate or not.
That's why we're here, though, because you're not contending that the 20-year minimum sentences individually violate the cruel punishments clause.
Correct, and I can get to that. Well, I was addressing what we would be asking the courts to be instructed.
Well, but I also want to clarify, though, this idea of capable of rehabilitation, that is a Miller factor. It's not a separate standalone factor. It's part of the statutory factors that the General Assembly set forth.
I have to look at the list in 1102.1.1, which he wasn't sentenced under, but children would be sentenced under going forward.
It's basically a statutory compilation of the Miller factors.
But the issue with that statute is that it doesn't require a finding of incorrigibility. And yes, I understand this goes back to Felder that reversed Batts, but Felder came down because of Jones. But in this case, where we are in a new world, where there is a holding that Section 13 is broader than the Eighth Amendment.
Well, this is the question Justice Donahue envisioned in her Felder dissent, right?
It is. Well, I think it was
Was it a concurrence?
concurrence. It was a concurrence, yeah.
But I mean, that's now we're here. That's exactly what we're here to address now.
Yes.
And what are you asking us to do with the Batts 2 factors and the Batts 2 holding, which we abrogated based upon the principle that we needed a constitutional mooring in order to instruct trial courts to do what we told them to do in Batts. And with the Jones decision, that constitutional mooring was gone. Your argument is we now have a constitutional mooring?
Yes, absolutely.
Okay. Well, and I think the question is important because although we have a trial court here who made findings of fact on the record, there's no requirement that that be done. So, I mean, unless we put appellate courts in a situation where they know what they are reviewing, which was the purpose of Batts, to enunciate the reasons for the decision. Unless we go back to a system that requires that type of fact-finding, I'm not sure that we could ever effectuate what you're asking us to do.
I agree. I think that it would be necessary to effectuate a finding in Ivory's favor. There would have to be a requirement that there be a finding on the record of incorrigibility or capable of change and rehabilitation. I think that's right.
Let me ask you the next question that was part of Batts, no longer exists. Whose burden is it to establish the fact that the juvenile is not incorrigible?
It should be consistent with Batch 2, in which the burden was on the state. There was
But we would have to go back to all of that, is what you are suggesting. I mean, I'm straight out, are you asking us to rejuvenate Batch 2 under the moorings of Article 1, Section 13?
We would agree with that. I think there are ways in which you could come out in Ivory's favor that you wouldn't have to. Yes.
I'm asking you what you want.
Yes, that's what we want. Yes.
Wouldn't that be a quote clean unquote way, efficient? Well, let me just erase that. Would that be a reasonable disposition in your view of this case for us to say now post Jones and post Lee, we're reinstating Batts 2, and he gets his hearing, and by the way, in that regard, regardless of what Senior Judge Boylan said in the lower court, at this new hearing, all avenues would be open. In other words, you could lose in this analysis in the trial court, right?
Well, I think when it comes to Ivory's case, the answer would be no, because he did have his sentencing hearing, and the Commonwealth did have an opportunity to present an expert. Whether or not they were required to under BAPS 2, they still had the opportunity to, and that was the time for them to present evidence.
That's not, is that appropriate? I mean, now we're in the weeds, but shouldn't both sides, the Commonwealth and the defendant, in that remand context, have the full and fair opportunity to litigate according to the new rules of the road? Because it could affect strategy, could affect presentation, witnesses, et cetera.
That's fair, and I'd say for the majority of cases, yes. I would just say for Ivory's case in particular, the Commonwealth conceded Miller and that he was capable of change and rehabilitation in its closing argument to the court, told the court to give him credit for all of those things. So I think they'd be in a difficult position to argue they should be allowed to present evidence. But I take your point. It would be fair for other cases in being remanded for resentencing to have that opportunity. I want to address one thing, Justice Brobson, you raised that I don't think I got to answer completely, and then also Chief Justice Todd. On the aggregate issues, the Court of Appeals in Alaska did address this in, I think it was State v. Fletcher or Fletcher v. State, one of those. In that case, the defendant, a young girl, was convicted of 2 first-degree murders and 1 second-degree murder, and the court did take into consideration, and it was aggregated. I think she had 45 years to life consecutive, and it was aggregated. And that court went through analysis about how its constitution is broader than the Eighth Amendment. And for that reason, it's very core. If we look at the Eighth Amendment cases, none of them spoke to the number of crimes as being the dispositive factor. It was the nature of the crimes. I mean, the nature of the child. And you have to look at the fact that children are less culpable because they are capable of change, whether it's one crime or more.
Do you worry, and maybe this may not have any relevance, but I just wonder this idea of yet another resentencing. If we adopt your view that anytime a trial court makes a determination applying the Miller factors that the convicted juvenile is capable of rehabilitation, cannot issue a de facto license, de facto life without parole in the aggregate, that in particularly heinous crimes and situations, particularly like this, a trial court judge may either be silent on that finding or might find that they are not capable. And what happens if that happens? Do you appeal under an abuse of discretion, or, I mean, is that where this is going to go?
Well, if we were in a world in which we got the relief that we sought and a trial court judge did find, based upon the evidence presented to him or to her, that this child is not capable of change and rehabilitation, then that would be a constitutional sentence under the question presented today. We haven't argued, this is not a case about...
It's going to become a battle of the experts and on rehabilitation, and a trial judge will be pretty much free to select which expert the trial judge wants to pick.
Well, they may be, but...
What do you mean?
I mean, yes, they would be. But I think that happens all the time anyway. And so I think that case from the child who said... The case of the child who argues that finding was improper is not before us today. And that will be a case that this court may see another day. We're starting from the beginning, which is that now that Section 13 is determined to have more meaning, how do we effectuate that for children? So that may happen, and again, a case for another day.
But there were no experts in this case, were there?
There were. There were 3.
Rehabilitation?
Yes, well, yeah, there were 3. So this case originally was supposed to go to sentencing hearing, and this is important regarding another issue, in 2018. It got stayed pending Felder and Faust, and it was something we had asked for, so I'm not saying Commonwealth did that. Before that happened, we did submit 3 expert reports to the judge and to the Commonwealth. One was a forensic psychologist.
Is that part of the record?
Yes, it's part of the record.
Is your client's sentencing memorandum part of the record as well? I didn't
The
notice that when I was
sentencing
looking at that.
memorandum is it's not part of the record, it is in the docket. We do refer to the docket section. Dr. Robin Timmy, who is the forensic psychologist, his report is in the record, and I can find it if you need it, as well as his testimony at the sentencing hearing. And he concluded that Ivory is capable of rehabilitation, and that all the Miller factors applied in his case. We had a second expert, Kathy Ganal. She is a prison adjustment expert. She reviewed his entire prison record, and based upon...
Prison record post-conviction?
Yes, post-conviction.
Should that matter for purposes of sentencing? If you kind of go back to the time of the crime, why should the post-crime period be relevant to sentencing?
It was relevant for all of the juvenile lifers who were eligible for relief post-Miller. That's what courts did, because it did give them some evidence of, okay, well, we know what the child did. We know what the evidence was at the time of the trial. What do we know now about the child, and has the child changed, and are they capable of somehow integrating as a productive member of society one
Good
day?
behavior while their appeal is pending.
I'm sorry, could you?
Good behavior by the juvenile in detention while their appeal is pending.
Yes.
Is relevant.
It could be relevant, yes.
Well, this was 7 years worth of, this was 7 years worth of experience with
26 years.
with your client, though. I mean, there was...
Oh, me? Yes.
Yeah,
Some pre-Miller behavior even.
yeah.
Yeah, no, all the...
And it is relevant.
It is relevant, and the judge did take into consideration his prison record from the time he was incarcerated all the way up to the time of the hearing. And so Ms. Ganal, what she did is based upon her experience working at the Department of Corrections, she concluded that he had done a lot of programming and did everything he could in prison to rehabilitate himself. And then there was a mitigation specialist. And the Commonwealth did have the opportunity to present an expert. They had our reports for 4 years before the new sentencing hearing, and they chose not to call one. Yes, Justice Mundy.
I looked at that part of the testimony, and it seems to me it's just maybe a little bit gratuitous about the rehabilitation, only because the trial judge set it in conjunction with his past offenses while in prison. So it wasn't really quite clear to me, and I may be wrong, that his rehabilitation was as being a successful or less problematic prisoner going forward, or truly whether the judge thought he was rehabilitated enough to move out into society.
Well, I'm glad you raised that. And to be clear and candid, because you can read the record, the judge said he was not rehabilitated yet. But the yet part is the critical part. And there is something I do want to address in conjunction with that, because I'm quite sure the Commonwealth will raise it. The judge also found that the crime was not due to transient immaturity. So the Commonwealth, I'm sure, will say, well, if it wasn't due to transient immaturity, then he's not capable of rehabilitation. So I want to address that. What the trial...
Just framing that.
Yes.
Before you, just framing this for the court. Regardless of that sort of granular stuff, if you win on the larger question and we order a hearing that everybody has an opportunity to litigate ab initio, this could all be sussed out later and he could win or lose, right? I mean, the bigger issue is what brought us all here, this de facto, right?
Yes.
Whether Mr. King, gets out or Mr. King doesn't get out is very important to you, but doesn't have to be so important to us as the larger question is important to us. Am I right?
That is correct. And I would also say that all we're asking for is that this court give children a chance to see the parole board. It may be that whether it's Ivory or another juvenile who gets a term of years where they first see the parole board, they may never get paroled. And the court even acknowledged this in opinions and concurrences in Lee. You're not making a decision about who should get out. That's left for the parole board. All this is about is giving an opportunity for children who are less culpable, who can change, a chance to see a parole board.
Question that could be raised by the Commonwealth or people who believe this side. Your position is that despite the number of victims, the maximum should be 35 years. In essence, does that not create a perverse incentive for a youth to kill more than one person knowing, hey, I could shoot out my classroom, but I think I'm going to go after the next synagogue?
So, no, I don't think so, because one of the elements of youth is that they don't think ahead. They don't think about the consequences of their actions. And when, for example, when Roper came down, or Miller, or any of these cases that found that children are different and so they shouldn't have the most severe punishments, there wasn't all of a sudden a spike in juvenile crime. So I don't think that's a legitimate concern.
Judicial responsibility of being concerned about safety of the community when we as trial judges
That's absolutely true. All of the penological factors do apply. However, when we're talking about children, those penological factors are diminished. And in terms of safety of the community, that's something a parole board will deal with. Parole board seats a child after 35 years or maybe earlier, depending on the sentence, and might say, no, this kid is not ready, this kid is still a danger to the community. So the court does have that responsibility, but will take that into consideration in imposing a sentence that requires the child to see the parole board.
Counsel, let me, along those lines, let me raise an issue that I'm certain opposing counsel will issue. What about the concept of retribution?
Yeah, I think
that, how does what you're suggesting give weight to that particular factor, which is an allowable consideration in the sentencing scheme?
it is an allowable consideration.
So what's your response to what your opposing counsel is undoubtedly going to say about that issue?
Of course. I would refer to this court's decision in Lee, where this court talked about retribution and cited Graham. And what this court said is that, pardon me, I need these now. Yeah. While society may impose severe sanctions to express its condemnation of a crime and seek restoration of a moral balance, even with retribution, there is a proportionality principle, as, quote, the heart of the retribution rationale is that a criminal sentence must be directly related to the personal culpability of the criminal offender, citing Graham. And as we know, the personal culpability of children is reduced. I don't want to minimize this here. The impact to the families in this case, it's unimaginable. The impact to any family that loses a loved one to violence is unimaginable. But what we're here to decide, what we've asked this court to decide, is what does the Constitution of Pennsylvania require in terms of humanity in sentencing?
And the parole board consider the retribution factor?
I'm not familiar with whether that's one of the requirements, but I think that generally the parole board can consider whatever they like. And as this court also pointed out in Lee, the parole decision is not appealable. So that is something that is critical to remember for those rare children who may not rehabilitate, who may remain a danger.
I'm not sure I'm right on this. You can correct me if I'm wrong. I think they are reviewable in the limited sense of if there's a constitutional violation.
That may be correct.
Their discretion is not reviewable as an abuse of discretion, but if they violate a constitutional right, perhaps don't parole somebody because it would be cruel not to parole them. I'm just wondering how far that goes.
Not the question before this court.
Got it. I tend to think down the road a little bit.
That is totally fair. I tried to think down the road also of all of the different things that could be asked. I don't know the answer to that, but I think that would be, a question for another day. But, Justice Donahue, to your point, I think, yes, retribution is considered. However, when we're talking about children, retribution is diminished penological justification, just as the others are. I did want to mention, though, what I do think the Commonwealth will bring up, although, Justice Weck, to your point, you're thinking about sort of a broad rule as opposed to just my client. They may bring up the fact that the court said that the crime was not one of transient immaturity. And I just wanted to remind the court that when the Supreme Court talked about transient nature of childhood, they were talking about the things that made children different, the things that are changeable. And so, for example, in Miller...
Not the specific crime?
Yes. So, for example, in Bats 2, this court dealt with that. The trial judge in that case had also similarly found that the crime wasn't one of transient immaturity. And this court said, you're talking about the fact that this crime was premeditated, which it has to be for first-degree murder. However, Miller and all the other Supreme Court cases, those were all first-degree murder cases. And more importantly, the judge said not once but twice, first when she imposed the sentence on the record, he can change. And then when she issued her 1925 opinion, she said, hold on, this court did, and she underlined did, find appellant was capable of rehabilitation based on defense expert and other testimony summarized earlier in this opinion. And that she had referred back to the expert testimony as well as the testimony from 2 prison employees who testified about all the good work he'd done in prison and how they felt that he was really a model inmate.
Except for that time he put a guy in the hospital.
Well, yes, and by the way, both of those DOC employees knew him at the time, and they did testify about their understanding of that situation, as well as their view of Ivory, regardless of that situation. But also, more importantly, the judge took that into consideration.
Your client benefited greatly by the passage of time.
My client, like most children, took time and matured. And he continues, while it's not in the record, you know, we're all works in progress. He continues to work on that to this day. His case, as were all the juvenile lifer cases, demonstrations about how children do change and how well the juvenile lifers have done once they have been paroled. The recidivism rate, which we quoted in our brief, is minimal. And that's 1, showing that children do change, and 2, showing that the parole board is making good decisions.
So at the risk of asking another down-the-road question, let's say you prevail here and we send it back. Does it go back for a new hearing?
For Ivory's case, we have asked that the court vacate his sentences and remand with instructions to the court to impose a sentence not to exceed 35 years, whether the aggregate or if she decides to run them
Shouldn't the
concurrently.
Commonwealth, if we're going to issue a new ruling, shouldn't the Commonwealth get the benefit of a new sentencing hearing?
I would say no, because they did have the opportunity to present expert testimony. They had our expert reports.
In
They
this
chose not
case,
to.
other cases maybe, yes.
In other cases, yeah, I'm only speaking of Ivory's case, based upon the unique circumstances. In other cases, the answer would be yes, or
So
could
you
be
would
yes.
basically not give the trial court judge, we're going to set a new standard, not give the Commonwealth court, the common pleas court judge another opportunity. You're saying law of the case, findings are findings, and we're done.
In Ivory's case, yes, that's what we're asking for. I recognize this court may make a different decision based upon your question, but that's what we're asking for.
Don't take my question for what this court will do.
I mean, if we sent it back for hearing, and I mean, I understand you're asking us not to do that, but under the protocols that we've discussed, the burden would be on the Commonwealth to establish
Yes,
that
that
your
is true.
client, and they may forego doing that, or maybe not. I
Yes.
mean, because what you're asking us to do is to really adopt or re-adopt a rule that we once had in place. So the evidence might be different.
Yes, that is true. And take that into consideration that it may make sense for all of the remanded sentences to have a new sentencing hearing.
You're interested in having it put back to before Jones that all juvenile murderers are presumed capable of rehabilitation.
Yes,
It's the burden on the Commonwealth to prove otherwise.
yes, because Section 13 being broader, when
And there's not a dichotomy of any difference whether it's a single murder or whether it's 4 or 5 or 6 or 7. Same test.
Correct, same test. And that would make sense because in BATS 2, what BATS 2 was, BATS 2, as you know, was trying to implement the substantive findings of Miller and Montgomery, and then in Felder found that Jones gutted those. But here, the argument we're making is that cruel punishment means something bigger, and so to effectuate a prohibition on cruel punishment, the BATS 2 procedures would need to be re-implemented.
Ms. Heller, I don't want to cut you off on the Pennsylvania constitutional argument if you have more to say, but at some point I don't want to lose sight of your second argument regarding the as-applied challenge under the 8th Amendment of the U.S. Constitution.
Yeah, I mean, I think there, and I'm happy to answer any questions about it. I think we can rest on the briefs, but the argument that we've made is that while Jones finds there doesn't have to be a finding, in this case, the court made the choice to make a finding, and under that finding, the substantive rule of Miller and Montgomery requires that Ivory not spend the rest of his life in prison. And I'm comfortable asking any questions, but can rest on our papers on that.
All right, any other questions? Yes, very, very well done, thank you.
Thank you.
Let's hear from the District Attorney's Office, Mr. Fegley.
Good morning, Madam Chief Justice, Justices. John Fegley from the Bucks County District Attorney's Office on behalf of the Commonwealth. There is nothing cruel about making a mass murderer have their sentence account for each of their victims. That is a Commonwealth policy of not affording volume discounts. It has been for a long time in this Commonwealth.
Well, I know we toss that, some people toss that term around, volume discount, but is there anything that would stop a court, let's say this case goes back, is there anything that would bar the common pleas judge from taking account of each of these victims individually and sentencing accordingly while still recognizing that humans don't live forever?
Well, in this case, remanding it, that would be possible for the judge to do. But based on the number that was thrown out today of 35 years, you're talking about 8 years per defendant. That absolutely devalues the human life taken. You're talking about a sentence that equates to a robbery for a first-degree murder. But in every case going forward, there's a mandatory minimum of 35 years for a 17-year-old that commits first-degree murder. So,
Well, there's not a mandatory minimum. Well, I'm sorry. There's not a bar on a de facto life sentence. In their formulation, there's a bar on a categorical imposition of that, right?
well, there would be a bar. In 1102.1, puts a mandatory minimum of 35 years. So if they killed more than one person, it would have to be a concurrent sentence, and they would not be able to account for each victim with that sentence for every case sentenced after 2012.
What would be the problem that you would have with individualized consideration of such cases? Because presumably then the judge would have the ability to determine that this particular defendant, for any number of reasons, including the volume of killings he did, was not amenable to release.
Well, first of all, I believe that determination was made here. They did take the defendant as an individual, and they applied all the individualized sentencing factors under Title 42. And they came up with 20 years, which was a mitigated sentence under the law, and deemed it to be consecutive to get to the number that took into account all those factors. But again, going forward, if there's going to be the rule adopted that no juvenile murderer should get a sentence over 35 years, that's removed, because that's the mandatory minimum.
That's not the rule. I mean, there's the crucial element of the determination that the juvenile is capable of rehabilitation. May not be the case in all cases, although certainly Miller would anticipate that it would be unusual, but I think it's incorrect to start with the proposition that all juveniles are entitled.
Sure. No, I was just keeping with the rule requested. Under those facts, there would be no ability to take into account anything else. And to be clear,
But the 35 that you're talking about is the minimum, right?
yes,
Well,
Yes,
there'd be
that's-
no, I'm sorry, go
The
ahead.
maximum could still be life.
yes. But no, I was answering.
So yeah, I think we have to be careful, because I can sometimes get this messed up in my head when we stand up and we simply say, oh, 35 years is only 8 years per person. That's the minimum for parole eligibility. You can still be sentenced to life. This defendant and other juvenile defendants could still spend the rest of their life in prison.
Sure. No, I was answering the question about what would stop a sentencing court from taking into account each individual victim if they found capable of rehabilitation.
But the point is that even if sentencing is aggregated rather than individual, there's no disability on the judge in finding on an appropriate record that this is the worst of the worst, and we're keeping him in, right?
Correct. If they made the appropriate findings.
But that's without, if we accept Ms. Heller's argument, that's without consideration of the number of victims.
Yes. Well, also to be clear that
I don't think that's right, is it? I mean, in other words, that universe of fact findings that could be done by the court on the remand, well, here would be remand, but on the sentencing would take into account the whole world of what happened in the case, and in such a case could very well include how many people that this person murdered, right?
Well,
So-
just before you answer that, I think that the focus was on the nature of the child, not the nature of the offenses. So that's
But
different.
your expert opinion on whether or not the child is permanently incorrigible would certainly take into account the nature of the crime. I mean, and that's why I think, it's important that there be a remand in this case, because it's going to be your burden / opportunity to establish that, given the nature of the crime, and other elements, of course, this individual, this juvenile, is one of those rare juveniles who is incapable of rehabilitation. I mean, there are many cases that talk about the difference between maybe a case like this, where you have a 2 or 3 or 4 incidents that happened in rapid succession, versus a situation where a juvenile goes on a crime spree that goes over the course of months or even a year or so. Certainly, that evidence is something different about the child's psyche, and I mean, that's what experts take into account. So, I mean, I don't see that the number of victims is really eliminated from the equation. I just think that in terms of an expert analysis of the case, it has a different place in the analysis that would be presented to the court.
Now you have 3 questions to answer.
So let me start off by saying, first, if there was a remand in this case, I do believe it's out of fundamental fairness necessary to have a new hearing, because the Commonwealth was presenting evidence based on Felder's decision that we're only applying Chapter 42's considerations and not anything else. And the evidence was tailored to that, and its decision to not seek a life without parole sentence was tailored to that. To speak to the facts about what the experts may or may not take into consideration, that just makes the number of victims one factor to consider in the expert's determination of whether or not a child psychologically is capable of change. It does not put it within the sentencing judge's discretion to craft a sentence under the sentencing code of a sentence that takes account, after making its findings, of the impact on the victims and society. So while it would be one factor to be considered on the capable of rehabilitation question, it would not be ultimately a sentencing factor if it was outweighed by other considerations.
But if I'm understanding their position correctly, the appellant's position correctly, tell me if I'm wrong, if after this remand hearing, the sentencing judge determines that the juvenile offender is not incorrigible, is capable of repetition, the highest minimum, individually or in the aggregate, that could be imposed is 35 years.
That is the rule they're asking for.
Okay.
Under this case,
You're saying the problem with that is that because that is it, the only discretion that the court would have to take into account multiple victims is to go all the way up to the 35 minimum.
correct.
But I think that's fair. The follow-up question then is, what is the reason why you lack confidence in the court's ability at that 35-year mark, assuming it's the 35 years, to take into account holistically everything, including the multiplicity of victims at the time of the crimes?
Well, for the court, again, to take that into consideration, if we put this hypothetical cap of 35 years, the math it would have to do to divide to get that number now comes to the point where we're devaluing the human life.
Well, you did that before, though. And the dividing thing is where I think I'm having a problem following you, is the rule simply is 35, no matter how many, you talked about the volume discount, no matter how many heinous murders there were, if the trial court finds if the trial court finds that the juvenile is capable of rehabilitation as a matter of law, the minimum for all of those cannot exceed 35. Now, then you want to do this division aspect, and I understand that, but it's a minimum of 35 to life. So if you're going to do the division, you got to do the division on both ends, because it's entirely possible that the parole board may say, no, we're not letting him or her out.
Well, that's the decision for the parole board, though, not
But
the
you keep
sentencing.
looking at the minimum, and I understand why you're looking at the minimum, but the only purpose of the minimum is to make you parole eligible. That's the only purpose of it.
Well, the minimum is what the victim sees at the sentencing hearing. The minimum is
Well, I
what
know,
takes
and we
it.
may need to do a better job of educating the victims on that, instead of talking about the minimum, but, I mean, district attorneys all over the Commonwealth of Pennsylvania understand the difference between a minimum and a maximum.
Certainly. But again, it's, the minimum is what takes into account the impact on the community and the victim by statute. It's not necessarily the whole choice that the parole board is making.
Counsel, if I may. We're here today to determine whether the departure claim which we found in Lee should be applicable to juvenile sentencings today. The question I have for you is, did you believe, or what's your feeling as to whether the defense even preserved the claim before us pursuant to our decision in Commonwealth versus Bishop, which I believe was 2019, saying if you're going to make a constitutional challenge, it must be explicitly briefed and discussed, which is not in the defense's position.
So Commonwealth v. Bishop said you have to do more than just state the Pennsylvania claim and say there's more. There's a footnote in Commonwealth v. Alexander that said it a little differently, and I believe the question that deals with that tension is presently before the court in Shivers, which is pending decision.
With regard to this case, do you have a position, does the Commonwealth have a position as to whether the defense raised the departure claim?
Yes, the Commonwealth argued in its brief before the Superior Court and this court that it was not properly preserved under Bishop, and it was not properly preserved in the 1925 concise statement that there was no request for greater protection. There was various as-applied requests, but there was for either one in the trial court or in the 1925, it was not properly preserved for a departure
Is this a
claim.
departure claim? I thought we're talking about the Eighth Amendment issue now.
Well, the question of viewing de facto sentences in the aggregate is a departure claim because the federal courts have held that it does not matter under Jones, being that there's no specific fact-finding. The Third Circuit, specifically in Grant, followed that even if there's a gratuitous finding, it does not matter in the aggregate if it's de facto. So that portion of asking us to basically change Faust and overrule it was a departure request. If I could also add, if there's not any more questions on that, the question of capable of rehabilitation was not alone what Miller talked about. That was a factor in Miller. Miller itself asked, and Montgomery and Jones stated, that the question is whether the nature of the crime reflected transient immaturity. It didn't say whether the defendant as a whole was capable of rehabilitation. That was one factor to consider. And when they issued Miller and Montgomery, they did not contemplate retroactively looking at 40 years later of behavior. So that was not the sole factor at issue in those cases. And I would argue that the judge's decision in this case of finding capable of rehabilitation and just considering those factors is not outcome determinative. On the question of whether the crime reflected transient immaturity, the trial court found to the opposite, and that is actually the question which Miller said to ask. So on that basis, there is no Eighth Amendment violation, and there would be no cruel and unusual because the finding of, again, Chapter 97 in Title 42, capable of rehabilitation concerns, was not an Eighth Amendment finding. And the trial court was clear that it was not making Eighth Amendment findings after Bats 2 was dissolved. It was making general findings under the discretionary sentencing. So the court's finding here is not binding on the constitutional question.
Is it irrelevant?
I wouldn't say it's irrelevant. It's why it found the discretion to impose consecutive sentences and the number that it ultimately concluded on. It was relevant towards the question that Felder told the court to ask was consider all of the normal statutory factors in exercising your discretion. So it was relevant towards that.
Are you saying then that in a scenario where you did have to go back with this case and have that hearing, that none of that could come in?
I'm sorry, none of the evidence would come in?
The rehabilitation,
prior findings.
the rehabilitative efforts, to the extent they existed during the years inside.
I would say it would come in and it would be a factor, but the judge would not be bound by its decision of capable of rehabilitation because that was not the question it was answering. The question of permanently incorrigible and does the crime ask whether or not the child, or does it reflect transient immaturity in the child, was not before the court. So the court would make new findings, considering even that factor, and then answer the ultimate question of Miller and the statutory factors that were taken from BATS 2 in
What do you
1102.1.
think that ultimate determination is?
I'm sorry?
What is that ultimate determination? You said the court will then make the ultimate determination.
So you're asking me to predict the sentencing court's outcome?
I'm saying, what is the realm of possibility there, in your view? for
I mean, the
ultimate-
realm of possibility is going to be the trial court still finding that the crimes itself, the heinous nature of the crimes in killing 4 people and wounding severely a 5th person, still outweighs what he has done in prison since then, and that the crimes itself, taking everything into consideration, may still not reflect transient immaturity.
I don't know. I mean, you know, the whole notion underlying Miller that the juvenile's diminished capacity and heightened capacity for change. I mean, Jones said they were merely mitigating factors. We are talking about that issue, that fact, as an eligibility requirement. So if in fact there is a finding that the child is capable, the juvenile is capable of rehabilitation and change, that would preclude a sentence that would not allow that individual to ever potentially see the light of day. And keep in mind, that's what we're talking about. You're talking about 35 years as the date on which a juvenile walks out of the prison doors. That's not it. That's not what Miller requires. That's not what they're arguing the Pennsylvania Constitution requires. They're arguing that what that individual is entitled to is just maybe the possibility of walking out of prison.
Understood.
So I don't know if a judge can find the capacity for rehabilitation and also intransient maturity.
The judge also heard evidence here and credited that evidence that as late as 2010, when participating in courses with the victims, he was still disclaiming any remorse for killing at least one of his victims, and that when he was talking to the guards and in his classes, he was still lying about the nature of the charges as to what happened.
You could certainly lose. I'm sorry, I meant the defendant, Mr. King, could certainly lose. I mean, supposing this goes back and he gets a hearing, and the trial judges, like Justice Kennedy wrote in Harmelin, there's no one dispositive factor in the proportionality review. There's certainly a very good chance that the judge would say, yeah, we're going to keep this guy inside. We're not satisfied. He loses. In other words, my point is, isn't it the case that Mr. King could win on the process question, but ultimately down the line lose on the outcome question? You follow what I'm saying?
By the outcome being the ultimate sentence or the determination of parole?
His sentence. In other words, suppose you lose on the first 2 questions here, and this goes back. And the judge does have to aggregate, look at the real world impact on years and all that. Could still find this guy loses, and I'm keeping him in. I'm not satisfied under a proportionality analysis, looking at all the factors, including how many he killed and everything else, that he is not getting out. But that outcome can coexist with a ruling by the court that these de facto categorical sentences are unconstitutional. Isn't that correct?
I'm having trouble asking, when you say he could lose, are we...
Stay in for life, de facto.
The judge could resentence him to exactly what he was sentenced here.
Yes.
That could happen.
Yes, after the outcome of a new hearing and new factual findings.
That's my question. I mean, you would concede that could eventuate, right?
It could, yes.
But the issue here is that, and this goes to my point about what one common pleas court judge may do or may not do based on our decision here. In order for the judge to do that, in order for the judge to give primary weight to the offense, the judge would have to necessarily find that the defendant is incorrigible and incapable of rehabilitation. That's under their theory, that's the only way. You could have the most heinous crime in the world, but if a judge says, he's capable of rehabilitation, been doing really well in prison, leading a prayer group, all these things, if the judge makes that magic finding, doesn't matter how heinous the crime is. That's the argument, I think. Am I wrong?
That is the bright line rule they're advocating for. Ultimately would be what this court held, ultimately whether or not that was adopted.
So there's no balancing test. That becomes the predominant factor for purposes of establishing the floor of the sentence.
And the proof is in the Commonwealth's hands. I mean, that's why the burden is on the Commonwealth, given the presumption of a juvenile having the capacity to change. You would offer evidence to the contrary, I would assume, which you didn't do in this last round because there's no reason for you to do it.
Correct. But I would also argue, as we're here talking about the departure claims, Lee was not dispositive on this claim before the court. Much like the search and seizure jurisprudence, it's a question by question, doctrine by doctrine basis. It's not wholesale, everything gets greater protection. So while the history and the text questions have been discussed at length by Lee, there are still remaining considerations. And it's the public policy of Pennsylvania specifically, a discussion of other cases, and the ultimate text of the meaning of cruel as applied to this case. And Lee specifically limited its decisions of cruel to instances where there is not a specific intent to kill. So while Miller talked about even specific intents to kill being diminished, it did not rule them to be zero. So it is not, again, necessarily cruel because they have diminished capacity to multiply that by the 4 people whose lives were taken and the 5th who was severely wounded. As for the other states, there were many talked about by the appellant, but the states are split on this. There is not a clear rule, and Lee has indicated when they're split, it's not a heavy factor. So the ultimate claim here that will be carrying the most weight is the specific public policies of Pennsylvania. And public policy in Pennsylvania has historically not afforded special protections to juveniles accused of first-degree murder. They were excluded from the Juvenile Act. They were treated like adults. And Justice Todd, when she was on the Superior Court, authored a law review article outlining how historically children were not granted special protections at all, which Justice Todd opined was why we had such lenient sentences for child predators in 2004. So the history of Pennsylvania, as better articulated in the brief with the case law, does not weigh in the juvenile's favor to depart from the Eighth Amendment claim here and to view these sentences in the aggregate. Rather, Pennsylvania has a strong volume discount, a strong history of protecting the victims individually and viewing sentences as they protect the public policy, which also is to deter future mass killings. While they indicated that juveniles don't have forethought and therefore deterrence isn't a strong factor, no one has opined that they never have forethought and they never think of consequences. It might be diminished, but it is still a factor.
Counsel, regardless of the history of the Pennsylvania Constitution, aren't we not bound by Eighth Amendment jurisprudence that's predicated on the fact that juveniles have a diminished capacity and the capacity for change? I mean, how do we get around that predicate notion?
Well, the diminished capacity, again, it's diminished, it's not zero. And that's why
And that's why you consider the possibility for change.
Yes, but that's also why in Graham they said it was doubly diminished because it was not in specific intent to kill. It's not, again, it's not zero. It is a factor that they have culpability and they have the ability for foresight. And Miller said they can't get mandatory life based on that. It does not say that if you keep killing, if you keep committing crimes, your sentence cannot be increased accordingly. It says it has to be considered and you can't get a mandatory life sentence.
What's the difference? And that's the, I mean, back to the whole core of the case. I mean, are we required to close our eyes to the fact that 80 years or whatever aggregated is life? again, whether or not that's judged appropriate in an individualized hearing is another matter. But are we supposed to ignore the fact that it is life?
Well, for Eighth Amendment purposes, it's not life without parole with a mandatory sentence. The Eighth Amendment said they have to have a discretionary hearing. Jones clarified a discretionary hearing where the court was able to take in youth and all the factors that come with youth and their ability to change before it imposes a sentence. They just can't give life without parole without doing that.
Well, and isn't part of your argument that the individual crimes, the sentence for each murder was not cruel or unusual? It was not cruel punishment under Pennsylvania because one murder should be looked at as one sentence.
Absolutely, and for each murder, he received a mitigated sentence because of those factors. The fact that he chose to continue killing is what got him the sentence he was. The sentencing court gave great consideration to all the evidence presented, and it factored that in when it started with the 35 as Bats 2 commanded and deviated downward based on those. But the fact that he continued to keep killing is what got him where he was, and Miller does not present that, and Jones does not prevent
Well,
that.
but that's why we're here, and isn't that that's the crux of their issue? I'm not saying nub. Inside joke. The issue here is they don't want just a Miller factor sentence. They want to elevate the rehabilitative aspect to the primary factor that makes the sentence constitutional or unconstitutional under the Pennsylvania Constitution.
Well, they want a bright line rule.
Well, but they want to take one of the factors and make it the primary factor. And if that exists, it doesn't matter. The other factors don't matter. That's pretty much what they're asking for.
Yes, they're asking for a bright line rule that does not exist under the Eighth Amendment.
Well, I know, because they want it under our Constitution.
They're asking for it for departure, and our argument is that even following Lee, in this specific realm, there is not grounds for departure based on the full factor consideration.
All right, Mr. Fegley, thank you. Before you both leave, those were outstanding arguments by Attorney Fegley and Attorney Heller. And I just want to point out that our court always encourages, when we speak to the bar around the state, we always encourage public service and pro bono service. And the two attorneys who argued here today really exemplify that: public service as a district attorney and pro bono service as defense counsel. And the court commends both of you. Thank you.
Thank you both. Thank you. Thank you.
CBM Ministries and Selson agency versus Commonwealth. Representing Commonwealth, Mr. Joseph Fresh, representing CBM Ministries, Mr. Gold.
I'm good.
Released time is a statutory program in which public school students are voluntarily released from school to receive religious education during the school day for up to 36 hours per school year. CBM Ministries, Inc., doing business as Joy L. Ministries, is a nonprofit religious organization that operates 87 released time programs in 8 Pennsylvania counties. CBM provides release time transportation to public school students with vehicles that it owns, transporting students from their schools to nearby churches for the release time program and then back to school. In September 2015, the Pennsylvania State Police cited CBM for failing to comply with PennDOT's school bus regulations, including the lack of identification as a school bus and the fact that the buses were not painted National School Bus Yellow. We granted review to address whether CBM's buses are subject to PennDOT's school bus regulations, and in doing so, to address whether under the relevant laws CBM is a school, whether CBM's buses transport school children, and whether CBM's buses are school buses. Please proceed.
Madam Chief Justice, other justices of this court, may it please the court, Jacob Frash, on behalf of appellants the Department of Transportation, its secretary, the state police, and its commissioner. A casual observer watching the 3rd, 4th, and 5th graders out of their public school in the middle of the school day onto CBM's buses, and then an hour later walk back from CBM's buses back to their public school, still during the school day, would likely agree that those children walking along are school children. The parents of those children, especially if they knew that the General Assembly had told PennDOT to ensure the safety of vehicles transporting school children, would likely assume that PennDOT could, for example, tell CBM that the wooden floors of its buses can't have rotting holes in them, that the seats on the buses have to be firmly bolted to that floor, and that the emergency exits have to be functioning properly on those buses. The Commonwealth Court, of course, concluded that CBM's buses were not subject to these regulations, and that PennDOT, in fact, was powerless to subject CBM's buses to these regulations. But as we explained in the brief, PennDOT has the authority to regulate these buses, both because CBM operates a school and because the children on CBM's buses are school children, and because the vehicles that CBM uses walk like, quack like, and are in fact school buses. The Commonwealth Court's erroneous conclusion, rested on 2 flawed presumptions. First, it believed that CBM could not be operating a school simply because it was teaching solely religious subjects. And it relied on Supreme Court precedent saying that those classes couldn't be held in public school. Well, that could be said as well of parochial schools, which the General Assembly explicitly instructed PennDOT to regulate.
So here's, I mean, what do you think a school is? Because, I mean, you represent PennDOT, right? The General Assembly passed this law. You live in a world of regulation, you live in a world of government. Do you really think that the General Assembly, when they use the term school in the statute, when they passed any number of statutes and regulations that talk about parochial schools and private schools in the academic context, that they also meant to regulate a ministry that provides religious classes?
I certainly think it meant to regulate the vehicles owned by...
Well, but in order for that to happen, it has to be a school. And that's where I'm struggling, because you seem to adopt this definition of school that is wherever there is instruction on anything. Not math, not science, not history, not English, or any other academic subject. If someone is teaching something somewhere, it's a school.
I think someone teaching somewhere something can be a school. I think CBM...
Well, then what makes it a school?
Well, the fact that they're teaching someone somewhere something.
But that happens in every house of worship. Just to follow up, if I may, because you might have a situation where it's a school bus because it's taking them to or from the school, the school they were taken out from to get these religious instructions, right? And it might be school children, but you might not be able to convince us that this CBM is a school, because by extension, aren't you necessarily taking the position that every house of worship of any faith is a school?
I don't think a house of worship is necessarily a school. I think that they might provide educational programs, which might mean they're operating a school. But I also want to say...
Well, is it a school then?
If they're providing an educational program...
Well, of course it does. I'm not aware of any that don't.
But it's not an educational program. It has to be a class for instruction.
The program...
The question I have for you is similar to my colleague. Is it your position that this bus is a multifunctional school activity bus?
It is the position of our clients that is a multifunction school activity bus.
Let's go through the language. The school bus used to transport students on field trips, athletic trips, or other curricular or extracurricular activities, but not used for to and from school-based activities. I read that
At a minimum, these are extracurricular activities. And the phrase extracurricular activities, if you're talking about a college application, can include anything. Piano lessons, soccer, doesn't have to be, that's what the prefix extra is, right, outside the curriculum of a school.
So you're enhancing, when you follow that, your position, extracurricular activity is the state public school educating children in a religious belief. Doesn't that violate the establishment clause?
I'm not sure I understand your question.
You're saying, I'm taking a child, a parent comes in and says, I'm taking my child, he's going to your CCD place, I want him to be a Catholic. He picks the child up and takes the child to CCD place. They're only instructed about Catholicism, nothing else. Are you telling me that personal familiar instruction is an extracurricular activity of the public school?
I think, respectfully, I think that your question assumes that the extracurricular activity has to have a connection to the public school.
Why would it not? That's
Because it's extra.
of school activity bus.
The definition of multifunction school activity bus, a bus used to transport students on field trips which are connected to schools.
It's a school bus, not a bus.
Well, and to be clear, all of these buses that CBM owns and operates were manufactured as school buses, and they meet.
The Partridge family was manufactured as a school bus.
That's correct, and they met the industry definition.
Showing your age, Justice Brooks.
Well, and this, I'm glad you brought this up, because they meet the industry definition of a school bus.
No, but
Type.
Could you read the rest of the definition that you were reading?
Multifunction school activity bus, field trips which would be connected to a school, athletic trips which may or may not be connected to a school. There could be extra school type athletic leagues. Curricular activities certainly would be.
Let's go back. You're saying that when Villanova puts its students, the basketball students, on a bus, so they can go play a Villanova-sponsored activity, that's a school. But an individual being taken out of school so that they can get CCD classes, that is a school athletic trip. I'm confused with your definition.
It is an extracurricular activity. The word extracurricular means outside the curriculum of a school, right? So if I am applying to a college, I'm a little old for that, but if I'm applying to a college, maybe and it lists extracurricular activities, I might list piano lessons. They weren't given by my school. They weren't given by any school. They were given by a gentleman in his house.
that would be a school, under your definition.
It would. In fact, I have taught, it would be a school. Now, the question, there's a separate question here. If the court is not inclined to rule that CBM is a school, it doesn't have to.
Well, but let's stick with the extracurricular thing. I jumped in and got off of it. But, travel sports have predominated since I was in school. Not that I was a great athlete or anything like that, but,
Oh, come on, yes, you were.
there are all these travel teams now, travel softball, travel soccer, travel baseball. And if after school, a bunch of students and their parents want their athletes to go to train at a particular facility that is one of these travel programs, not run by any school, a travel program, I mean, if by your definition it might be a school, you consider that an extracurricular activity where if the travel organization or even the parents for that matter secured a bus, it would be a school bus.
Yes. If
That's
transporting, well, hold on, if it were transporting school children, which is in the definition of school bus, which a multifunction school activity bus must be first. If it were transporting school children to or from their public or private or parochial school, or events related to those schools.
But extracurricular, by your definition, means anything not affiliated with the school.
That's correct.
Which means extracurricular could be, I'm going to take my son or daughter out to dinner later, and we're going to talk about our religious faith, which takes me into a school, which means the transportation is extracurricular, which means I need a school bus.
So I think that's, we're confusing some of the definitions a little bit. So that doesn't make you a school.
Why not? I'm teaching.
Well, you might be teaching, and maybe you are considering that you're operating a school for your children, and
Yeah, but the question is whether the government believes I'm operating a school. That goes back to my original question. I have a where I'm struggling with your case, and I try to make these very simple because I don't consider myself very smart, is I think this case rises and falls on whether CBM is a school. And if you can't convince, four justices up here that CBM is a school as the General Assembly intended the use of the word in this statute, where it's used it all over the place in other statutes, that if you can't convince us that CBM is a school, you can't win, right?
well, first, I don't believe that I have to convince you that CBM is a school, because I believe that the second sentence of 4551A independently gives PennDOT to ensure the safety of transportation of school children, whether they're on a vehicle owned by a school bus or by a school or not.
Let's bring this back to 1546, release of release of pupils for religious instruction. The superintendent of the school district shall, upon written request of a parent or other person in the local parentage, excuse any student who is the child of that parent or person from school attendance for religious instruction. Clearly, that language specifically says the school is advocating its responsibility for a maximum of 36 hours a week to a parent, should that parent desire to have that child educated in their fundamental beliefs. How do you distinguish school bus from a statute that says school district shall mandate and excuse actions from the school? It's not an extracurricular activity engaged by the school. It is an excused request of a parent exercising their constitutional right to have their child religiously raised. I'm really confused. Tell me how we're supposed to read that in its entirety.
I'm not sure I understand the question, but I think my...
1546 specifically requires a parent to seek permission from the school district for their child to be excused from school-related activity for a maximum of 36 hours so that that parent can educate the child religiously so that we keep a separation of church and state. That's what that says. Tell me, why would you not follow that? Or how is that different from your application that this extracurricular activity, religious instruction only, is school activity? Because you initially made a comment like a parochial school, being parochially educated. We also have math and religion and geography and all the other curricular requirements of a public school education. Thus, we were a parochial school. When you're taking your child separately for religious instruction, that's exactly what it is, and it's to be considered in 1546. What I'm asking you is to share with me, for us, how your 171 definition falls within 1546.
Well, I think this is a great point about CCD, because I was raised Catholic, but I went to the public school. And once a week, the buses from the elementary parochial school came to our school and picked us up and took us for an hour, and we messed up their desks, put gum underneath, and then brought us back.
Did they have a contract with the public school, the bus company?
In my case or in this case?
In your case?
Oh, I don't know. But
See.
my point is that parochial school still had to follow the school bus regulations.
Of course they did.
It
They
didn't.
were a parochial school.
School.
Right. It didn't make them not a school. But again, as I'm understanding, I understood your question to say that if they are taken out pursuant to the release time statute, all of a sudden they can't be regulated as school children or on a school bus. But if that,
Only for religious instruction at a maximum of 36 hours a week.
but if that's the case, then the buses that came to pick me up in elementary school couldn't have been regulated. And that can't,
We weren't.
well, they were,
No, but we're here today to decide what is paramount.
Well, in your analogy or your remembrance, your buses were parochial school buses that were already in use for the parochial school.
That's correct.
That's different, yeah.
I was just making the point that if the release time statute, I understood you to be reading the release time statute as once they're off, a release time cannot be served.
Well, this is what I think Justice Doherty is asking you, and I don't want to put words in his mouth, but he raises a very interesting point. If I schedule a dentist appointment for my child during the school day, and I go in and I say, excuse my child from school for this hour, we have a doctor's appointment. While I'm at the doctor's appointment, does my child still meet the definition of a school child?
I think it does, if it's during school day, if they're planning on.
When does my child stop being a school child?
Well, the dissent below would believe that your child does not stop being a school child until he or she graduates. I don't think the court has to go this far. The facts of this case.
This is all about in loco parentis. This is all about all these regulations and things like that are designed to protect the schools because they are in loco parentis for the children. And when the parents turn the kids over to the school, all these regulations exist to protect the children with the school. You seem to extending those protections to situations where the parents voluntarily remove their children from the school and put them somewhere else authorized by law, not for an education, not for math, science, reading, academic things that we license schools in Pennsylvania for, but for something else. Maybe it's a scout troop. Maybe it's a cooking class. Maybe it's something. But at that point in time, when the parent says, give me my child back, I'm taking my child somewhere else, they cease to be within the control of the school, and therefore the school shouldn't be able to regulate them.
Well, the statute explicitly says that PennDOT has the authority to regulate vehicles engaged in the transportation of school children, period. And on the facts of this case, during school hours, they're
during the school hours, the parents said, I want my child back.
That's correct. They are selected because they're public school children. They're selected under a provision of the public school code. They're going from and to their public school in the middle of the day. There has to be some verification once the program is over back to the public school. Yes, we did what we told you to say.
Right. Now we're giving them back to you.
But on the facts of this case, and as I started out, a casual observer watching those children is going to say, yeah, those are school children.
I don't know. Okay. You and I just may have a fundamental disagreement about it. I think it's very interesting that PennDOT is so interested in this situation, but hasn't, at least that I didn't see, show any interest when school districts were transporting children under the age of 10 by public transportation.
I can't speak to that. I will point out.
I know you can't speak to it but it really isn't relevant to this case. But I find it's just so curious that we'll put them on a SEPTA bus or a public transportation bus with any number of people. We have no idea who they are. They could be on the registry for all we know. But here you're worried about this.
That leads me to an interesting point, which is 4553, I believe it is.
Oh, I'm aware of it.
If a school child can only be a school child when they're in custody of the school, that would make the provisions of, I believe it's 4553, that talk about school children on mass transit vehicles nonsensical.
No, because the statute requires school districts to provide transportation at the option of the parents, by the way. It's an optional thing that the parents can avail themselves of.
But it talks about the school children on the mass transit vehicles.
Oh, I know.
And they're not in the custody of the school at that point.
No, but they're on school-provided transportation.
On buses that are not painted yellow.
And these
With potential people on the registry.
That's for another case, I suppose.
There I go again.
Doesn't your argument break down if you look at the definition of school bus? It's 171.2. A motor vehicle designed to carry 11 passengers or more, including the driver, and used for the transportation of pre-primary, primary, or secondary school students to and from public, private, or parochial schools or events related to these schools or school-related activities. This isn't a school bus.
Well, the buses are going to pick up primary school students at their school. They're taking them somewhere else for an hour.
They
are not taking to an event related to these schools or school-related activities.
But they're taking them to or from their private school. To or from public, private, or parochial schools. It doesn't even say their private or parochial schools.
Or events related to these schools or school-related activities.
Right. They are going in the middle of the day to and from their public school.
Then why do we need parental consent pursuant to the other statute?
Why do we need parental consent? Because the General Assembly says we do. But again, that doesn't mean that the parents couldn't consent to these children going to the parochial elementary school down the street. And that wouldn't mean that that parochial elementary school buses did not have to conform to these regulations, which, by the way, are designed to ensure the safety of vehicles manufactured as school buses. CBM brings up these situations where mothers driving their children in a Mercedes or something is going to have to get an S designation or an S endorsement on their license. A Mercedes is not a school bus, a Type A, Type B, Type C, Type D
Why
school
isn't
bus.
it?
Well, because it's not manufactured as a...
Well, the definition of school bus doesn't have a manufacturer, it has a capacity.
Oh, no, it has a type A, B, C, or D. It must be one of those types.
I thought there was one that said something about any vehicle that can carry more than 11 people.
That's what the General Assembly said.
Ooh, well, I mean, who should I listen to?
So the General Assembly thinks that maybe these regulations can be even broader than what PennDOT is promulgating.
What? You can't promulgate a regulation that's inconsistent with the statute.
Well, the statute defines school bus as 11 plus passengers
Right.
and used for the transportation of certain types of students. PennDOT has interpreted that to mean when the General Assembly said school bus, they meant vehicles that are manufactured as school bus, type A, B, C, and D.
What authority did you have to do that?
Well, they have the authority to interpret their own statute.
Okay.
All right, you know, we really do get it, and we're going in some circles, I think, at this point. So I thank you very much. Let's hear from Mr. Reddy.
Thank you.
Are you ready? How many times do you have to hear that in your life, huh?
All the time, Your Honor.
Yeah.
Good morning. Madam Chief Justice, may it please the court, my name is Joel Reedy. It is spelled Reddy, and I'm here.
Oh, I mispronounced it.
That's okay. I'm from Reading, Pennsylvania, which also usually gets mispronounced, and so
All
it's
right.
very confusing.
Thank you,
All right.
Mr. Reedy.
It's a pleasure to be here. I'm from Cornerstone Law Firm, and my co-counsel Randy Wanger is here alongside me as well. I represent CBN Ministries of South Central Pennsylvania, better known as JOYL. Section 4551 commands PennDOT to create heightened regulations and a unique appearance and color scheme for school buses. Section 4551 goes on to restrict those regulations only to school buses that are owned by or under contract with a school district or parochial or private school. And
Enabling statute.
that's correct, Your Honor. And it does so for two compelling reasons. One is the mandatory nature of education in Pennsylvania, and the second is the unique place that school-owned and operated buses have in terms of their powers to operate on the road in Pennsylvania. Number one, we require parents to send their kids to school. If I don't send my kids to school, I not only get fined, they refer me to CYS for a dependency hearing. They will take my children away on only the second offense of refusing to send my kids to school. As a result, for most working parents in Pennsylvania, they have to rely on the public schools running of a system to get those kids to school to comply with that statute. When you drop your kids at the school bus stop, you don't get to ask questions of the driver. You don't get to interview him and find out who he is. You don't get to inspect the buses. And as a result, PennDOT's powers are at its absolute height when it comes to this unique situation where we essentially take children by force from their children and then return them after school at the end of the day. That's why the statute refers to these school districts or parochial or private schools. But second, school buses are also unique on the Commonwealth's roads. School bus drivers have the power, they're the only non-emergency vehicle, by the way, that has the power to stop traffic in all directions until they offload or onboard a passenger. School bus drivers have the power to write tickets based on their own observations of violations of the school bus stop sign, and that ticket comes with a mandatory, non-negotiable 60-day license suspension. We give these school bus drivers extraordinary power because we assume they are operating for a state-mandated educational program. Now, my friends on the other side have attempted to expand the definition of school, I think, beyond its limits, but I don't think that holds up to close inspection of the statute for a few reasons. First,
you look at the actual phrase school is not the phrase that appears in the statute. It is school district or parochial or private school. No one would think in general that that refers to a dance academy, a flight school, a person going out doing a driving test, a vacation Bible school, or the number of other examples that we've heard here today. But also, second, if you look within the statutes themselves, they back this up. Just one example, 4552G requires that every school district administration or the administration of any private school in the Commonwealth must do 2 fire drills a year with all of their students to make sure they know how to get on and off the buses. In Joey L's case, if their camp is a school, and during the summer they run to pick up kids an hour and a half away at a church parking lot and bring them to the camp, and then at the end of the week they take them back to that church parking lot, if you read the statute the way my friends on the other side want to read it, they would have to figure out how to do 2 fire drills in that week to make sure that these kids know how to get on and off of this school bus. I think that actually it is... I think the safety issue actually moves in our direction on this. I heard about rotted out floorboards, and I want to be totally clear about 3 things. Number 1, our buses all comply with PennDOT's regulations already. They get inspected every year, and if there were rotting floorboards, they would be required to correct them. Your car can't have a rotting floorboard. Our bus can't have a rotting floorboard. Number 2, we comply with all the federal regulations, which includes regulations that govern vehicles over 26,000 pounds. There are already things we have to do. And our client, number 3, goes out of its way to take these buses in every 6 months for additional optional inspections. They did that well before this case started 11 years ago. They've been doing that for decades. They get anything repaired that they're told to repair, but they do things that these regulations tell them they can't do, such as putting a big logo on the bus or an advertisement for their upcoming programs. Recently, in the last 3 months, we got tickets for the font on the side of the bus not being within the regulations that are in this statute. The font and the size of the black lettering were wrong. Some of our buses...
What are they used for other than transporting school students?
We would argue they're not transporting school students,
What
but...
are they used for other than moving children from school to their facility and then back?
They are used for the summer camp program in the summer. So they go to perhaps a church or another location where people have congregated to get picked up. They're used during the summer camp sometimes for an outing, some kind of, I'm not totally sure where they go, but if they go anywhere, the buses would take them. But those are the main uses for these buses.
For children?
Correct, for children.
And by the way, those small human beings, those are school children, aren't they?
They are not, Your Honor.
They're not school children.
No.
So, contrary to all appearances, if it looks like a school child and talks and walks like a school child, experience teaches us it probably is a school child. So can you explain to this court why we should find that these are not school children?
I'll do my best, Your Honor. I'll give you 3 reasons. First, I would just point you to some of the internal language in the statute. 4553A2 describes situations where public transportation picks up these kids. And in those cases, when the school district is entering into a contract with one of these organizations to pick up the kids, then they're allowed to put a stop arm or a swinging control arm or things like that. I don't think my friends on the other side are serious that if a Port Authority bus picks up a group of tourists from Philadelphia today, that it's now a school bus.
But what makes them not a school, what makes the child not a school child, or what makes this not a school children case? Forget about the bus, forget about what the vehicle looks like.
Sure.
Middle of the day, kids go to school. They're allowed to go to special instruction during the course of the day on the proviso that they're brought back to school, and the additional proviso that somebody has to verify that said instruction was given and what it was. So where in that passage do they stop being school children?
When they're released from the school's custody. And
1546, where the school district requires a written consent to be excused from being a school student?
That's...
A familiar family's religious indoctrination?
That's correct, Your Honor. That's our position, and we think that the school doesn't want them to be school children during that time because it creates, when we talk about appearances, I don't think we want it to appear. I mean, imagine that the motorist follows that bus down the road and watches as the school children with the school district's labeling on the side drops all the kids in the church parking lot and they carry their Bibles in for Bible study. I don't think anybody in this room wants that to be happening.
Isn't your distinction, you're drawing a distinction between school children as sort of a possessory thing, like they're the children of the school at a certain period of time, versus school-age children.
That's correct, Your
draw a
Honor.
distinction between those two?
I do, Your Honor. And I also, if you'll see in our brief, we've cited a number of instances where the code goes out of its way to refer to kids as opposed to pupils or as opposed to students. When the code uses pupils or school students, it's typically talking about it in a school environment and their relationship to the school. And there's actually a good reason we want these buses to be visually distinct. First of all, it's for motorists on the road who, seeing a bus that is a traditional school bus or that is carrying school kids on a related school outing, knows that at any point this thing could throw out a stop arm. They know that it could end up in a school zone. There's a lot of reasons that that school bus excuse me, should look like that. But second, it's for parents. In front of my house at home, there's a school bus stop, and parents from all over the neighborhood bring their kids down and they drop them off in the morning. And when the bus pulls out and it throws out its stop arm and the swinging thing comes around, suddenly all of these PennDOT regulations make sense. The cleanliness standard on the outside, which is one of the regulations, the requirement that the lettering be a certain size, a certain font, a certain color, the national school bus yellow, the fact that there are no logos, no advertisements. Parents know at that point the guy sitting in the front seat of that bus, he's hired by or under contract to his school district. I can put my kid on the bus and not think about it. When Joyelle is coming to pick up kids, parents should ask Joyelle about the safety of their buses. They should ask the dance studio about the safety of the bus. They should ask the travel baseball team, well, who are you hiring to do this? They should ask and can ask those questions, and if they don't like the answers, they can say, never mind, you can't have my kid. They cannot do that with the local school district or parochial or private school. I understand the school children question, and I would just note, for example, in 4552H, which they've cited in their brief, it says that they have to ensure the maximum safety of school children, but they've not noted the beginning and the end of that sentence. The beginning says, in ways not inconsistent with this section, and after that it says school children furnished transportation. We're talking about school children who are being given this transportation. Otherwise, there is no cabining principle here. My friends on the other side have no way to limit this. A limo taking kids to prom is a school bus because it's capable of carrying more than 11 children and it has a school child on it.
Well, how do you respond to their point that their regulations limited with the statute? That the statute would cover the limo, but as a matter of grace in their regulations, they've limited the reach of the statute.
Respectfully, I think it's the opposite. I think that the statute says that it has to be owned by or under contract to a school for this reason, because we didn't want limos and large vehicles swept in just because of the nature of their size or having a school child on board. It also reaches very absurd results. A single school child on the bus downtown makes it a school bus. That's obviously not what the legislature intended. I don't think they can regulate outside of what the legislature gave us.
So, counsel, doesn't the entire argument end to begin with the enabling statute and the statute that Justice Doherty gave you, which was 1546, which created the program? Because we keep coming back and answering these different questions, but the fact of the matter is, it's not owned by or under contract with a school district, right?
That's correct.
And number two, 1546 specifically exempts and excuses children who are being released for religious instruction as students.
That's correct, Your Honor. We believe that that's all you need to decide on this case.
But that's all premised on the fact that your client is not a private or parochial school for purposes of this analysis. So
Correct.
Your position would be, unless a private entity or parochial entity provides a full spectrum of curricula that's required under Pennsylvania law for children, they are not a school.
I would say maybe only slightly differently. I would just say that the school district or parochial or private school is referring to K through 12 mandatory education.
And where do you get that?
I get that from just my plain understanding of that term.
But if I look at a dictionary and look up the word school and I look up the word private?
I would ask you to do two things. First, I would ask you to look up the term school district or parochial school or private school, which I think is different from school. Again, a flight school can be a school.
That's what I said. You would say a parochial or private school cannot be a parochial or private school unless they provide a full curriculum of subject matter.
That certainly would be one way to define it, and I think you
Well,
also...
you have to define it that way because otherwise your client is providing instruction on a subject matter, just not every subject matter that's covered within what your definition of a school, private or parochial, would do.
That is correct, Your Honor, and I do agree they would have to offer the full gamut of education to be considered a school district or parochial.
And that is statutorily based in what?
That is based just in Section 4551A and also in the way that the rest of 45, 52, and 53 talk about school districts and school administrations.
But that's not what this is talking about. This is talking about under contract with any parochial school or private school. You're saying cannot apply unless that school provides a full curriculum of study. Instruction on one subject matter or two subject matters, or even three, is not sufficient unless they are providing the full spectrum of instruction that's required under Pennsylvania law.
Correct. I would pin it to what's required for it to satisfy the mandatory educational requirements in
Okay,
Title
and then
24.
again, where in the statute would I find that definition?
I'll give you two attempts to answer that. One is that this statute, and we've traced this in our brief, was broken out of Title 24. So this used to be part of the school code, and it was referring to the schools as defined there in the school code and their mandatory educational programming. But second, to the degree that it remains undefined, and I understand that then we have to grant it a definition, I would just ask the court to look at the way that school districts and their administrations are referred to throughout 4552 especially.
Well, you can read them in peri materia with the school code.
Yes.
I mean,
Yes.
Can CBM get is CBM licensed as a private or parochial school?
They are not.
Because their private and parochial schools are licensed by the Commonwealth of Pennsylvania.
They are correct.
Could they be?
No, I don't believe, I mean, no, not at this time.
You could not be because you never tried to be.
Well, you don't offer the academic things that the parochial and private schools must offer to get a license.
There's absolutely no math at Joyelle. Yes, that's right.
Right.
Yes, no, that's
You
correct.
wouldn't be able to get a license because you don't offer the mandatory minimum education requirement.
That's correct. We could not give
Say
license.
that's true of parochial schools also.
Well, sure. I mean, whether sure.
I am a perfect example.
And I would note, Justice Donahue, I mean, we have also, homeschooling co-ops that have the same thing. They have to meet a certain mandatory educational requirement, whether, and there's all sorts of ways that parents can do that, but this program is just not one of them.
All right, any other questions from the justices? Thank you both, very well argued.
Thank you.
Us for those appointments and for lunch, and then we will resume court at 12:30. Good afternoon, everyone. Please call the next case, Mr. Minner.
Commonwealth of Pennsylvania versus Tyrone Burse, representing Mr. Burse, Ms. Isabel Bard, representing the Commonwealth, Ms. Amy Thompson.
Under Section 4910, Sub 1 of the Crimes Code, an individual commits the offense of tampering with evidence if believing that an official proceeding or investigation is pending or about to be instituted, he or she alters, destroys, conceals, or removes any record, document, or thing with the intent to impair its verity or availability in such proceedings or investigation. In this discretionary appeal, we must determine whether a defendant, by discarding a firearm and detached magazine in plain sight of police officers from whom he was actively fleeing, altered the firearm within the meaning of the statute. Please proceed.
Good afternoon, Justices of the Court, Madam Chief Justice. May it please this honorable court, Isabella Bedard of the Allegheny County Public Defender's Office on behalf of Mr. Tyrone Burse. We are here to determine the meaning of alter within the tampering with physical evidence statute in light of this honorable court's holding in Delgado. Alter under this section means to materially change from its original form. As noted in several opinions and by the Superior Court, altered is not defined in Section 4910, nor is it defined in the Crimes Code. Therefore, we must turn to the common definition of the word, to change or modify to some degree. Here, the firearm with a detached magazine was not modified or changed in any way. It was still the Bodyguard 380 pistol, and the magazine being detached does not alter it in any sort of way.
Still a firearm.
Correct. It does not change in any way. In fact, it's still operable without the magazine in it. So under various sections, 6106, carrying without a license, and 6105, a person not to possess, it meets the definition of a firearm still, regardless. And in conjunction with that, tossing the firearm in plain view of police while attempting to initiate here an arrest, he was not tampering with physical evidence whenever he tossed the gun and the magazine came out separately. This honorable court held in Delgado in 1996 that abandoning contraband in plain view of police while they're attempting during an investigation and while the subject of the investigation knows that some sort of investigation was about to be instituted is just abandoning the contraband. Your Honor, respectfully, with concealment, it's pretty hard to conceal something in plain view of somebody else. That is what Delgado contemplated, and the General Assembly meant the verity or the ability to present the evidence at a subsequent trial or proceeding. Concealment in that case is inapplicable, I would say, in this case. Tossing a firearm, and the detectives, both detectives even noted that they were able to find it easily. He was simply in a wooded area, urban brush, in the Homewood neighborhood of Pittsburgh.
Concealment, to be criminalized within the meaning of the tampering statute, the concealment has to be successful. It has to be a successful concealment.
No, Your Honor, it doesn't necessarily have to be a successful concealment. But again, with that, if I were to hide something outside of this room versus try to hide something in front of you right here, you would know where it is. That concealment wouldn't be completed.
So for purposes of the concealment prong of the tampering statute, supposing that the fleeing suspect tosses the gun, the applicability of the statute in that context depends on whether the officer immediately recovers the gun or not?
The recovery here is not what's actually necessary. They still have the circumstantial evidence or testimonial evidence that there was a firearm present, and that all of that can be attributed to the underlying larger issue of concealing a firearm or having an illegal firearm at that point.
The reason I'm asking you, belaboring this a little, is that Delgado is one page of analysis. It's a two-page opinion with one page of analysis, maybe less actually. There's no discussion by the court of why it's abandonment and not concealment. And I guess, let me just try to end my line of questioning with you with this. What, to the extent the court chooses to treat the concealment aspect of this, and maybe it won't, can you offer a test that we can provide for guidance of what the distinction is between abandonment and concealment?
Again, I do think Delgado perfectly encapsulates that. You are in front of the investigating body. The investigating body can present that against you, and they saw it happen. When someone abandons evidence in plain view, that evidence is presentable. It's circumstantially or physically. Here, I would also say that the concealment element is not met. It was partial concealment. Detective Donnelly was able to locate it immediately. She knew exactly where it went. It was on top of debris and bushes. In fact, she stated it was laying on top of dirt and debris right inside a little patch of bushes that we observed him throw it into. That's on page 57 of volume 2 of the transcript. To say that it was concealed would mean she would have to have necessarily gone into some sort of bush that she couldn't reach into. There's no evidence of that here. And
Are you suggesting, is this a mens rea question? Is it when I chuck a thing of drugs or I chuck a firearm or a piece of a firearm, I have to do so under circumstances that I believe the officers can't see me?
that is one of the elements, yes, Your Honor. So that would be part of it.
So you're saying in Delgado, as in here, you're saying the facts don't show that he had the intent to conceal.
Correct.
That he did have the intent to discard or abandon, but because he was in plain view, a jury could say he was in plain view, he either was stupid, I guess, or something like that, but he couldn't have formed the intent to conceal because he knew police officers were looking at him.
Correct. I would agree with that, Your Honor, yes. Yes. It goes to the intent, but it also goes to, whether the investigating body was there, able to see it.
There's got to be an intent to preclude its use or evidentiary value. I mean, that's the second half of the statute, correct?
Correct.
This isn't just in concealment. I mean, you take out a magazine from a gun and you throw it somewhere and the gun throws it somewhere else. The evidentiary value in this particular case of even if you concealed the magazine, it doesn't impair the evidentiary value of the gun, does it?
No, it does not.
That's the Delgado holding, which is, it's basically trying to distance yourself from contraband. I've got a more granular question, if you don't mind me asking. When does contraband become evidence? Because the statute concerns itself with evidence. I mean, is all contraband evidence? Does it have evidentiary value? Because it seems to me that this particular statute, tampering or fabricating with physical evidence, the intent is to impair its use or evidentiary value at trial as opposed to distancing yourself from the object.
Correct, Your Honor. I would also say that another prong of the three-factor test is that the suspect would know that it would have been important to the investigation, or could have been part of the investigation, knowing an investigation was about to be instituted.
If I grabbed your pocketbook and put it in my book bag and I'm running down the street and a police officer sees me, if I take my book bag, the pocketbook out of the book bag and just drop my book bag, does that mean I've concealed evidence? I mean, if it's used in the commission of a crime, sure, but is that contraband or is that evidence? In other words, when does contraband become evidence for purposes of this tampering statute?
Your Honor, I believe that would be kind of a fact-intensive question, as are most of these things. The difference in being, next to a river and tossing a gun versus just being 50 feet from the officer maximum and tossing a gun to the side of you is pretty fact-intensive. But where contraband, I think contraband itself explains that it could become evidence at any point. Much like the possession of an instrument of a crime statute, I think that is analogous to your question. When does an AirTag become an instrument of a crime versus simply having an AirTag on you? I think that sort of question or that sort of analysis comes after the fact, after the investigation, when it's presented at proceedings. Those things, when it's used to come to some sort of answer or theory.
Then it's fact intensive, as you just said. Doesn't that suggest it's for the jury?
Yes and no, Your Honor. I would say in this case, it could be for the jury if, I would say it's for the jury to determine whether or not this sort of evidence could have been prevented from being brought forward, not necessarily just tossed to the side and abandoned.
Put it this way, the whole 1 or 2 page opinion in Delgado comes down to basically one sentence, where the court says, well, there's concealment and abandonment. We think it's abandonment. This was a bag of cocaine, is what it was, wasn't a gun. Why is that for a court to declare rather than for a jury to determine, given the language of this statute?
I would say the difference for the court to declare that is different would be in the situation where, because it is so fact-intensive and so granular and it's so legal, it goes a lot of things into that, like whether or not, again, if it's held that you're just simply abandoning evidence versus tampering with it. I would say that it's a legal determination by the judge to show that, in that case, that this is not an illegal act to toss something next to you, versus smashing a gun, obliterating a serial number, smashing a crack pipe in front of you, or swallowing a packet of drugs, where you double down on the ability to control it and get it away from the investigating body.
You're saying the words in the statute are legal terms of art that the judge has to instruct on what those words mean, basically, is what you're saying.
Exactly, yes, Your Honor.
Can we go to your river analogy? Because I think that goes back to this question that Justice Wecht and I were asking about what is concealment and what is abandonment. And you said, well, obviously, if he does it in plain view. What if he throws the gun into the river in plain view?
That could be considered tampering because it fully, again, doubles down on the suspect's ability to control the evidence.
So it's really not a question of plain view. It's a question of concealment would be an act that renders or tends to render the evidence not available. It doesn't really matter if the police officer saw them do the concealment. It matters what the effect or intended effect of the concealment was.
I would say that could be a factor that can be considered in that case.
So then why wasn't Delgado wrong? Because it's not like he just dropped it next to him. He threw it up, presumably to try and prevent the police from getting it. He didn't just drop it.
At that point, I would say it's because it's easily recoverable, which is, whether we like it or not.
Terrible concealer.
Yeah, but where does that come into the statute? You keep focusing in response to the questions on this issue of control. Where does the statute have anything to do with control?
It's the ability to impair its verity or
The truthfulness, the verity and useful, that's what I said to you beforehand, the usefulness of evidence at an evidentiary hearing or trial. Doesn't have anything to do with control, though. I mean, if I'm standing on the corner and I got a vial of crack and I see a cop car coming down the street and I put it in my pocket, am I guilty with tampering of evidence? Because I've concealed it in my pocket?
I would say no, because there's no, you have no reason to believe that a investigation were about to be instituted.
Well, if I see a police officer rolling down the street in a marked vehicle and I'm about to engage in a narcotics transaction and I put the drugs in my pocket, haven't I concealed it? Is that tampering with evidence?
No, I would say that
But under Justice Weck's response to the question is concealing, any concealment whatsoever, putting it in your pocket, putting it in the bush. Philadelphia, back in the day, they used to actually use a stash location. Somebody would walk up to them, they would walk over with, inside of a car, abandoned house, trash can. They would get a vial of crack out and they'd walk up, putting it back. I mean, if I put the,
I think they still do that.
They still do.
Yeah.
I said back in the day, I was,
Back in the day.
I mean, is that concealment?
I would say regarding concealment, we do have case law that's instructive on that. Both Montgomery, that was decided by this honorable court, which showed that if you're kind of aware of what it is, then that's not necessarily concealing it. Having the butt of a gun, if it's, kind of in your front pocket and everyone's apprised of what that can be, again, like here, tossing it into a bush, the officers knew what it was and were able to see it easily, really wouldn't be concealed. He tossed it into a bush, they found it on top of a pile of debris. It wouldn't be concealed based on the record.
All right, any other questions for Ms. Bedard? Thank you very much. Let's hear from Ms. Constantine. You must like it here. Keep coming back.
Good morning, good afternoon, Your Honors. Amy Constantine on behalf of the Allegheny County District Attorney's Office.
Thank you. Would you pull the mic closer there?
Thank you.
Thanks.
As the appellee in this case. I would note that this court recently decided the case of Williams, wherein this court decided what alter means. And specifically, this court determined that it means to make different in some particular as size, style, course, or the like, or to modify. The Commonwealth submits that viewed through this lens, the Superior Court perhaps did not err in determining that Appellant altered the firearm in this case. That is a rather broad description of the term alter, and the Commonwealth submits that it very well could include the separation of the magazine from the firearm in this case.
How did that impair its ability to be used, to be of evidentiary value?
I'm not sure that that's the standard, Your Honor. The standard would be...
The statute said it alters, destroys, conceals, or removes any record, document, or thing. And then the second part is with intent to impair its verity or availability in such proceeding or investigation.
Well, the success isn't... His success in doing that it did not occur, I don't think affects the fact that he attempted to, or had the intent clearly to remove
removing
or
a magazine,
conceal.
alter it, destroy, or conceal it.
Isn't it still a firearm?
It's a firearm, but it's been altered pursuant to this court's definition in Williams.
So if I have a pen and I take the cap off the pen, have I altered the pen?
Yes.
It becomes absurd, doesn't it? I mean, if you see how this can go to an extreme that rapidly becomes ludicrous, right?
It could, Your Honor, but under the facts of this case, the Commonwealth submits that this alteration occurred and the Superior Court can't be determined to have erred in determining that in this regard.
In Smith, if the serial numbers being scratched did not constitute an alteration, why does having a magazine detached from the gun constitute an alteration, particularly since if you had a firearm, you were sitting at home cleaning it or whatever, so you didn't have the magazine in it, and the firearm's sitting there in your room, it's still a firearm, isn't it?
It's still a firearm, but I haven't done anything to try to preclude its availability as evidence in an investigation. And the Commonwealth, at trial, argued not only referred to the scratch serial number as an alteration, but also proceeded on the theory that appellant removed or concealed the firearm pursuant to the tampering statute.
You're talking about this case or Smith?
This case. I don't think the statute says that, Your Honor. And nor did this court. Not necessarily. Not necessarily.
But it's not an attempt. You haven't charged attempt at 903. I mean, you haven't charged the attempt. You've charged the crime, right? So you could have charged maybe you did, I don't know, but that's not before us. I've got the complaint here. But criminal attempt is one thing, tampering's another. Would you agree?
Yes.
Interestingly, in Williams, it was the addition of a file that, in my opinion, said was altering. In this particular case, following the Delgado philosophy that abandoning of a gun is in tantamount to that charge, you're asking us to criminalize the removal or the disengagement of the magazine, correct?
To the extent it constitutes concealment or removal of evidence, yes.
But we're here on altered. This specific issue was altered. So what I'm sharing with you, or I'm asking you, is the fact that if he just threw away the gun, there would be no such charge based upon Delgado. But you're using the Williams case, which was the addition of evidence, not the removal of evidence.
But
you want us now to criminalize the disengaging of a magazine from the firearm when both are thrown.
Yes, because it was done with the intent to impair that evidence from being used as evidence against him in his possession.
Evidence of what? What is a magazine evidence of?
Evidence of his illegal possession of the firearm.
But he had the firearm.
He discarded it.
Well, say he didn't, let me just go right down the road. Say he just took the magazine out, threw the magazine, and still had the gun in his belt. He discarded, did the same exact fact pattern. We're talking about a magazine here. What evidence does that impair?
I would submit in that case it could be a different outcome. I would also submit that Delgado doesn't provide a lot of guidance as far as it uses the term abandonment. And when a defendant is abandoning evidence, it strains credulity to believe that that is done with any other intent.
I'm just trying to, I'm thinking down the road. Essentially, if we determine that this constitutes concealment or alteration, it's almost like we're telling every criminal defendant out there that, you can't distance yourself from contraband. In other words, you've got to just cooperate from the police. You got an illegally possessed gun, you just got to turn it over. You got some crack on you, you just got to pull it out of your pocket and show it to the police officers on the scene. How do we draw a line?
I'm not sure that that's such a bad thing to tell a
I'm
defendant.
not suggesting it's bad or not. I'm suggesting there may be a Fifth Amendment issue.
Well, I think the problem is, you hit it on the head, which is Delgado creates this distinction between abandonment and concealment without much discussion about when one abandons but doesn't conceal or when one conceals but doesn't abandon. And I think that's, so let's take Delgado out of the equation. Do you believe if this defendant had been running on a football field away from police officers and the police officers were 5 feet behind him and he threw the gun as far as he possibly could, maybe into the first rows of bleachers, is that concealment?
Yes.
Okay. So you have a problem with Delgado?
Yes.
Okay. But you haven't argued for us to overrule Delgado?
Not
You're
yet.
distinguishing it, aren't you?
I think that Delgado, in addition to the fact that it does not discuss the sufficiency of evidence and does not provide any guidance about what would constitute the relevant conduct under the statute, also stated that it did not believe that the legislature in that pursuant to the facts of that case, it did not believe that the legislature intended for that defendant to suffer a harsher penalty for a tampering charge than the underlying charge that he was
But
convicted.
in your non-Delgado world, every time a person in flight from law enforcement for engaging in illegal activity of which they possess evidence throws it away during the course of flight, which happens quite frequently, cell phones, drugs, guns, happens all the time, that would automatically prompt, or could, in a matter of prosecutorial discretion, could automatically prompt a charge for tampering.
I think that's a reasonable interpretation. And I do think that Delgado needs to be revisited, as this court has
But
acknowledged.
you've argued here, and because of the question granted, on an alteration theory. You haven't argued on a concealment theory.
Well, the Superior Court ruled on an alteration theory,
Right.
but at trial, the Commonwealth argued that there was concealment and removal.
But
Looking at this-
excuse me, Justice Wick, the question we accepted for review dealt with alteration.
Correct, so again, I rely on Williams.
But what I was going to ask in follow-up is, standing here today, do you think this conviction is stronger on a concealment theory or on an alteration theory?
A concealment theory, and as the Commonwealth also requested in its brief, to affirm on any other basis, affirm on another basis, the Commonwealth submitted that that was a possibility in this case as well. To affirm on another reason.
All right, any other questions for Ms. Constantine?
Yeah, I do.
Okay.
We granted on precisely the issue you asked us to grant on.
Well, I didn't ask.
I'm sorry. We granted on that, and part of it is a challenge to the Superior Court's interpretation of Delgado. Do you think the Superior Court got it right or wrong? Its interpretation.
I think it was probably correct to the extent that it didn't rely on Delgado.
All right, thank you very much.
Thank you, Your
And
Honors.
Ms. Constantine, we see a lot of you in this court. I don't recall seeing Ms. Bedard before. Is this your first Supreme Court argument? Well, you did a very nice job. Thank you for being here. Welcome.
Thank you, Your Honor.
Bye-bye. Mr. Minner, would you call the next case?
Conyngham Township versus Pennsylvania Public Utility Commission, representing the PUC, Mr. Appellants, representing the Township, Mr. Peter Little.
In this appeal by allowance, we are asked to determine whether a borough sanitary sewer authority, which also provides sewer services to an adjacent township, is required under the Public Utility Code to obtain a certificate of convenience from the Public Utility Commission to operate outside its municipal boundaries. Please proceed.
Good afternoon, Chief Justice Todd and fellow justices of the Pennsylvania Supreme Court. May it please the court, my name is James A. Mullins, and I represent the appellant in these proceedings, the Pennsylvania Public Utility Commission.
Great. Could you pull the mic up? You're
Certainly.
taller than our last counsel.
Certainly. With me today I have co-counsel Sharon Webb. My presentation today centers on one premise, and that premise is the court below paints a picture of Court of Common Pleas jurisdiction over municipal authorities that is much less extensive than such jurisdiction actually is. Now, the court concedes that the Municipal Authorities Act establishes that the Court of Common Pleas shall have exclusive jurisdiction to determine questions involving rates or services of municipal authorities. So in the order below, the court asserts that there's a segment of complaints against municipal authorities that does not involve rates or services. And for this segment of complaints, the court asserts that the PUC therefore has jurisdiction. Now, that such complaints exist is implausible. Any municipal authority providing a service will assess a fee for that service. That fee will be reduced to a recoverable rate. Thus, for the court below to state that there's a segment of complaints against municipal authorities that does not at least indirectly raise issues as to rates or services is inconceivable.
Well, how do we reconcile the two statutes then? We're supposed to give effect to everything the General Assembly has passed into law with the governor's assent. And you're talking to us about the MAA. What about the PUC? Don't these two statutes cover the same area? What are we to make of, and counsel, just to be clear, I'm referring to the language in 66 PACS 1501, which reads, quote, any public utility service being furnished or rendered by a municipal corporation beyond its corporate limits shall be subject to regulation and control by the commission as to service and extensions with the same force and in like manner as if such service were rendered by a public utility.
So, Your Honor, there are several components encompassed in that question. I think we first have to start with a chronological examination of the two acts. So what we're talking about here is the 1945 Municipal Authorities Act. And pursuant to that act, any entity established under that act is under the sole jurisdiction of the Court of Common Pleas. Now, where we run into complications, I'll say, is that from the definition you just read, the definition of a municipal corporation does include authority.
It does not.
No, it does.
It does.
The definition.
That's what I want to be clear on. All right.
So, but we're talking about two different animals here, in that you can have an authority that the commission would in fact have jurisdiction over, but if you were talking about an authority that was established under the MAA, that's a different beast, and the commission does not have any authority whatsoever.
But my question, and I appreciate all that, but my question is, I know that's what you want us to interpret, but what's the tool or the guiding principle that allows us to privilege the MAA in this context over the PUC?
I think it's a simple matter of statutory construction, in that the 1937 Public Service Law established a definition of a municipal corporation. That definition also included authority in the definition. In 1945, the MAA was established, and in the MAA, once again, the General Assembly determined that for entities established under that act, the Court of Common Pleas would have exclusive jurisdiction. Now, in 1978, the Public Utility Code was enacted and contained the exact same definition of municipal corporation as the 1937 Public Service Law. So, the 1945 Act superseded the definition of municipal corporation that's currently in the code and that was currently in effect in 1937.
Why, well, wouldn't it, maybe it superseded, maybe it didn't, but it seemed to me that where you were going was you were going to argue that when the this provision 1501 was put into the Public Utility Code, the MAA did not exist.
Well, what we can't lose sight of is the fact that we're still talking about two separate entities.
No, I'm just trying to understand. You were making a chronology argument. I want to understand the chronology. Are you saying that when the definition of municipal corporation was placed in the Public Utility Code, that the MAA did not exist?
With the Public Service Law, at that point, the MAA did not exist. In 1978, obviously, the MAA.
When they created the Public Utility Code.
In 1978, but
right. So in 1978, when they created the Public Utility Code, I know you're saying that they incorporated a definition from a law that predated the MAA, but the General Assembly was very aware when it created the Public Utility Code of the MAA.
Right.
Right.
Yes.
So it did so knowing that the MAA was in existence, it nonetheless brought forward the definition, brought it forward, and made it applicable at the time the PUC code was, the public utility, gotta be careful, not the PUC, it's public utility, by the time the code was enacted.
Yeah.
It could have incorporated the MAA and say, except for municipal authorities created under the MAA, which presumably they knew about when they created the public utility code. You see that?
Yes, and that's why we're here, because that word authority still remains in the current definition.
But you want to relate it back, but we can't really relate it back. We have to look at what the intent of the General Assembly was when they created the Public Utility Code in 1978.
But once again,
And at the time, they knew about the provisions in the MAA about rates and service being in the Court of Common Pleas, but they nonetheless chose to include this provision 1501, and they chose to use the definition of municipal corporation.
yes, but again, if you take the East Dunkirk case, which was cited in the Appellee's brief, in that particular case, you had an entity that, when the complaint was brought against the entity, it was an authority. Not a municipal authority created under the Act, but a simple authority. And the argument was, does the commission have jurisdiction over this particular entity? And the courts below answered the question in the affirmative, that this is an authority. This authority is undertaking public utility service actions, so the commission can in fact regulate this entity. Now, subsequent to the end of that case, the East Dunkirk Authority then established itself under the MAA. And at that point, the commission said, well, now that you've established yourself under this particular act, we have no jurisdiction over you.
Look, I'm not disagreeing with you that the PUC's position is aligned with you. We're not here about that. We're here about whether the PUC's position is correct. And the Commonwealth Court said that it wasn't. So we're looking at the law. The fact that the PUC has taken that interpretation doesn't really matter that much to us. We're looking at the statute. And based on the principle of statutory construction I am aware of, the General Assembly was presumed to know about the MAA at the time it passed the Public Utility Code.
Well, if we want to focus on the General Assembly, then we also have to take into account the fact that in 2017 and 2018, one of those years, HB 798 was proposed by a member of the House. And that law would have brought all municipal authorities established under the MAA within the purview of the commission. Now, that particular bill languished in committee. Now, there was a hearing, but it languished in committee until the term of the GA, the Assembly, ended. So the General Assembly was well aware that the commission has never exercised jurisdiction over these entities, and when the General Assembly had the opportunity to bring them within the commission's jurisdiction, it chose not to.
Well, but we don't know why it chose not to. It could have chose not to because they could have said, we don't need to amend it because I mean, that's the problem. How do we know why they chose not to?
Well, I think that, coupled with the fact that since at least 1993, the commission has consistently ruled that it has no jurisdiction over these particular entities, lends credence to the fact that the Assembly has well known that this is how we treat our lack of jurisdiction for these entities.
What principle of statutory construction are you, because I'm aware of the one that says when the highest court interprets a statute that the General Assembly is presumed to know that. Where is the principle that when the PUC interprets a statute, the General Assembly is presumed to know it?
It's just a matter of consistency on behalf of the agency, and that in the case below, we've consistently held that we do not have jurisdiction over these entities. The current chairman of the commission back in 2017 and 2018 made the same point. You know, we simply do not have jurisdiction over these particular entities.
So I think you're arguing the converse of what Justice Probst is asking you, because in 1978, when the General Assembly passes the Public Utility Code, they imported the definitions from 1937, which defined municipal corporations to include authorities, but they were also well aware of the fact that the 1945 Municipal Authorities Act created jurisdiction exclusively with the Court of Common Pleas.
Right, and it would have been...
The converse is true as well. So I guess you're looking at basically They could have accepted one, but they didn't. They could have included one, but they didn't.
And I think we have to not lose sight of the fact that the cases that were subsequent to 1945.
Sure. They all hold that municipal authorities are vested with jurisdiction in the Court of Common Pleas, not through the PUC.
Right. So you've got the 1945 Act. You've got ample case law to the effect that when it comes to rates and services, and for that matter, any and all complaints that an entity or a complainant would bring before.
The course of conduct doesn't necessarily guide our interpretation of the Act. This is more of a situation where you've just got the General Assembly importing one definition, recognizing that it had previously defined municipal corporations to include authorities into the 1976 PUC, but by the same token, it was also well aware of the 1945 Municipal Authorities Act, which vested jurisdiction exclusively in the Court of Common Pleas. They didn't do anything to import that definition, nor did they do anything to exclude it.
I think it may have been a matter of there can still exist entities that have authority in the name.
You're going exactly where my thought process is.
Can you give us an example of one?
East Dunkard at that point.
There's authorities
It was an
and
authority.
capital authorities, which are municipal authorities created under the Municipal Authority Act. I mean, I did a fair amount of my prior experience representing municipal authorities, all of which, anytime there was an issue, went to the Court of Common Pleas. I've never even heard of the PUC being involved in a municipal authority.
Exactly, and to this day, there can be authorities out there that we're unaware of.
Well, but let's be clear what we're talking about here, because we're not talking about regulating the rates and services that a municipal authority and the MMA is providing to the municipalities that sign on to or have an agreement with them. We're talking about a municipal authority that is going outside of any connection to any of its original charter and the organizations that have contracted with it. So if this was a pure rates and service case about the services that the municipal authority of the MAA was providing to the municipalities that were a sign-on member of the authority, we would definitely be in the Common Pleas Court. But the question is, does 1501 kick in when a municipality withdraws from the joint municipal authority and the municipal authority says, well, we're just going to continue to provide service to that municipality anyway?
There's still two different and distinct entities, and that for municipal authorities created under the Act, they can serve anywhere within the Commonwealth.
Where do you get that?
In the Act itself. I can, 5607D.
It says they have no territorial limits.
No, not within the Commonwealth. No, absolutely not.
I didn't see that line. 56 what? It says
5607D.
expressly says they have no territorial limits.
Whenever a complainant has an issue with a particular municipal authority, that complainant can either file a suit within the Court of Common Pleas in which the entity was created, or the other jurisdiction in which it operates.
Principal office of the project.
Right.
I'm sorry, can I just really follow? But that didn't, now you're backtracking.
Well,
if I look at 5607, does it say words to the effect of, and a municipal authority created under this act can operate anywhere in the Commonwealth it wants to?
Not explicitly, but it certainly, I can.
I'll look at 5607. I mean, that would be an obvious, if it said that, we probably wouldn't be here.
And there's case law as well that says.
Not from this court, though, right?
I would have to check. I do have.
5607D9 says, apropos of Justice Brobson's question, the county where the project is located, or if it's in more than one county, the Court of Common Pleas where the principal office of the project is located. Let me ask you, Counsel, it could be another county.
And many of them do operate in more than one county, which is set forth in.
You know, there are cases where we're forced to decide that somehow the General Assembly has implicitly superseded one statute with another. It's just a conflict that cannot be avoided. But here, the Commonwealth Court reconciled these statutes, the Public Utilities Code and the MAA, by determining this was not a service. So if you're correct, sir, then there's no, is there any conceivable kind of regulation that's not a service?
I think that was my initial point, in that, first of all, the proceeding below did in fact address services, because the crux of the complaint was that this particular entity cannot serve township customers directly. So it was a question as to them exceeding their authority, their service authority, as it were. And as I've said before, any case that is brought against a municipal authority is going to involve their rates of service to some degree.
Obtaining a CPC is a service.
Well, when the commission issues a CPC to a municipal, well, I'll take a step back. For a municipal, any municipal that serves within its boundaries is not subject to commission jurisdiction.
Municipal corporations.
Municipal corporations,
Not
right.
authorities.
Right, municipal corporations.
Make that distinction, because you're about to walk into a.
So when that particular entity serves outside of its boundaries, the commission does have authority to regulate. For municipal authorities created under the Act, you don't have that same dichotomy, and that once again, they can serve anywhere within the Commonwealth. We spoke briefly about the legal justification for the court's determination below. And the court relied upon two panel decisions that were unreported in its justification for deciding as it did. Now, the first one is the Middle Smithfield case, and in Middle Smithfield, the court below states that, quote, the commission has in fact issued a CPC to a municipal authority. Now, in that particular case, the PUC issued the CPC to a privately owned corporation. Now, that particular corporation shirked its duties to such a degree that the PUC had to file an enforcement action against it before the Commonwealth Court. At the same time, the Pennsylvania Department of Environmental Protection ordered the Middle Smithfield Municipal Authority to take over the operations of that corporation. At that point, the municipal authority sought a certificate from the PUC for the private corporation to abandon services. In other words, the commission sought to rescind the CPC of the original holder. So,
Well, not rescind, reassign, right? It would be reassigned to a municipal authority, because municipal authorities aren't required to attain a CPC. In this particular unique circumstance, the court ordered them to take over the municipal corporation's rates and services, and that's why they were required to obtain the CBC, right?
Well, the CPC was for the private corporation to abandon service, and then obviously the municipal authority took over the service. But the point I wanted to make was
that was under a court order, right? Didn't the court tell the municipal authority to take over because they were either incompetent or they weren't?
If it wasn't a court, it was another body of authority that told them that you can't operate this system anymore. It has to be taken over and run effectively and efficiently on behalf of the customers. But the point I was trying to make was that it wasn't a case where the commission granted a CPC to commence service. It was a CPC granted to abandon service for the original holder of the certificate. Right. The East Dunker case, as I said before, was the court cited to that. But again, the facts of that case are that when the initial determination of PUC jurisdiction was made, that entity had not been established under the MAA, so it wasn't an apples-to-apples comparison. Finally, I'd like to direct the court's attention to the 1993 Schneider versus New Wilmington Water Authority case. That case is set forth or cited in the commission's brief. That case was ignored by the Appellee as well as the amicus OCA. And in Snyder, the PUC issued an order which, as in the proceedings below, unequivocally states that the PUC has no jurisdiction over municipal authorities as a result of the MAA. Since Snyder, once again, the Commission has been consistent in making that determination each and every time that question has come before it. In summation, as the MAA clearly confers jurisdiction to the Court of Common Pleas, as to the complaint below, the Commonwealth Court committed a reversible error in holding that the PUC had jurisdiction over the complaint. As such, the order below should be reversed. I'll take my seat unless there are any further questions from the bench.
Thank you.
Thank you, Mr. Mullins. Let's hear from Mr. DeLuca.
May it please the court, counsel. My name is Vito DeLuca. I represent Conyngham Township, the Appellee in this matter. I'm going to start because there was some discussion about the Commonwealth Court relying on those two unreported cases, one being Dunkard and the other being Middle Smithfield. And just to correct, I believe what may have been an incomplete summary of what happened in those two cases. In Smithfield, it was actually a filing for a certificate of public convenience to abandon it because a private corporation had been running the system, and when the EPA ordered the Middle Smithfield Authority to take over those operations, that was a necessary process to abandon that original certificate with that private provider of services. The thing is, though, in the first instance, that case doesn't help us one way or another because Middle Smithfield was serving its own residents anyway. It would have never needed a certificate of public convenience, even under the reading that we have and that the Commonwealth Court had a 5607 D9. So Middle Smithfield isn't necessarily helpful except to the point that the PUC did issue a certificate of public convenience, but it was at the request of the Middle Smithfield Authority, but the Middle Smithfield Authority didn't need one to begin with. The operation that they were taking over was within their own boundaries anyway. So that technically, that case, I don't believe I addressed it because it really is not, I don't believe it's completely relevant here. Now the Dunkard case is different. The Dunkard case was a case where they had taken over a private entity that had been operating in multiple jurisdictions. And when they took it over, Bureau of Enforcement got involved and said, hey, you're operating in all these other municipal entities and you don't have a certificate of public convenience. So Bureau of Enforcement went through with that action. They were required to get, by the PUC, to get a certificate of public convenience. And when I looked at what happened after the case was remanded, because that was cited in the PUC brief, what the Dunkard Authority did is they went out and they got consent from each one of those authorities. And it's actually listed in the exceptions that were filed when they were asking to reduce the fine for what they did by operating in outside their municipal boundaries. They said, we went through and we did all that was necessary to be able to basically to now eliminate the need for PUC oversight and jurisdiction, because they got the consent of each one of the municipalities that were involved with that. So Dunkard actually helps us because Dunkard acknowledged, they actually did go out and get a certificate of public convenience, and they resolved that by getting the consent of the municipalities that they were serving.
Counsel, what statute determines, I'm assuming you disagree with Appellant's counsel that municipal authorities have no jurisdictional boundaries?
I have to say, I have been struggling from the beginning of this litigation to understand what their position is with regard to municipal authorities with a small a, municipal authorities with a big A.
Well, let's just stick with there. Their municipal authority, you agree, is formulated under the Municipal Authorities Act, right? Not there, the one we're talking about,
Yes.
right? Formulated in the MAA.
Yes.
Under the MAA, does a municipal authority formed under the MAA have any jurisdictional boundaries?
There is a statement, I believe, in the MAA that says that they're basically given corporate status. But there are limitations within the MAA that limit what they're allowed to do and what they're not allowed to do.
So if there are jurisdictional limits to the services that a municipal authority formed in the MAA can provide, those jurisdictional limits would be in the MAA.
Absolutely.
If those jurisdictional limits are in the MAA, then why doesn't the Commonwealth, the Court of Common Pleas exclusive jurisdiction kick in as to questions about where they may engage in service? And you have to go to the Common Pleas Court to determine, are they engaging in service beyond their territorial limits as authorized under the MAA?
It's not a dispute that they're operating beyond their territorial limit.
I think it's very much in dispute because they're saying there are no territorial limits. That's what this whole case is about. You say they are outside their territorial limits. The PUC says they have no territorial limits. Therefore, they don't need a certificate. And that's what I'm trying to... Questions of rates or service. Isn't your authority under the MAA to provide a service in a part of the Commonwealth a question about service under the MAA?
I think that every time we talk about it's questions regarding the reasonableness of rates and services. That's the jurisdiction that I admit and agree is conveyed to the Common Pleas Court.
It would be unreasonable to provide a service in a jurisdiction that the MAA doesn't authorize you to provide.
It would be ultra vires.
Which would be unreasonable.
Which would not be under the MAA and would not be subject to that provision of D9. And that's where I'm finally, I believe, understanding maybe what the position is here. The Dunkard authority was ultra vires. They were acting without any authority under the MAA. So how could they get protection under the MAA if they were acting outside of the provisions of the MAA, which would give them authority to be under the Act in the first place?
When you say protections under the MAA, what are you talking about?
Because protection of the MAA by not having to have PUC oversight.
Yeah, but under the MAA, if you're a municipal authority, you're responsible to your ratepayers. I mean, municipal authorities and municipal corporations their enabling legislation is completely different. A municipal authority is established by an act of the township or governing body. So in other words, a township can decide, township's elected officials can decide, you know what, we want to incorporate or create a municipal authority. Those municipal authority board members are then, the authority itself is created under the Act of 1945, and then their board members are appointed by the township officials. They are then responsible to their ratepayers to establish the rates and circumstances. And if they're not providing the services and the rates that they want to, the MAA of 1945 says you got to go to the Court of Common Pleas within which you exist for any kind of dispute on rates and services. Municipal corporations are private corporations that are formed to operate within a certain jurisdictional boundary. They're subject to regulation by the PUC, which is, I mean, this is how I've always seen it. In this particular case, the township forms municipal authority. If the municipal authority decides to provide services to customers outside of the geographic boundaries of that particular township, there's got to be an agreement somewhere.
Under G19.
Correct. You can't just say, hey, we're just going to scoop in this particular neighborhood and provide you with rates and services.
That's
if you've got adjoining townships, but my point is that the township municipal authority doesn't just give services and set the rates unilaterally. There has to be a negotiation between them and the adjoining township.
Your Honor, that's why we're here. My township does not have a member on that board.
I understand, but we're here to decide the jurisdiction. Where does the dispute go? To the PUC? And they're saying We've never regulated or overseen a municipal authority, but we have overseen rates and services disputes as to municipal corporations. So I think that's what we're here to decide.
I believe that the General Assembly, in its choice of words in D9, when it said questions about the reasonableness of the rates or services provided go to the Court of Common Pleas. It didn't say just services and rates, which actually it seems to be as it's trying to be portrayed, that anything related to rates and services, basically they could have easily just said, Court of Common Pleas have complete regulatory jurisdiction over municipalities.
Well, that's not. So what do you want us to, how do you want us to define service going forward to try to give effect to both of these statutes?
Yeah.
How do we make sense of this, and where do we delineate between rates and services on the one hand and whatever else there might be, if there is anything else? I take it the PUC thinks there isn't.
Right. So the Court of Common Pleas jurisdiction, my position, and I believe the position of the Common Pleas Court, is to address questions of the reasonableness of rates and services. It doesn't regulate municipal authorities in the first instance, which is billing practices, which is all the other regulatory things that go along with what the PUC does when a public utility gets a certificate of public convenience. They have audits. They have financial requirements. They make sure that the infrastructure is safe for the residents that it's serving. They require them to produce reports. There are reporting requirements for when there's accidents that have to be reported to the PUC. Literally, and if you think about it this way, when we're talking about statutory construction, and trust me, I've seen more statutory construction in this case than I did in 35 years, and I'm not an expert at it. But I could say this, the one part of the Statutory Construction Act that I looked at was the absurdity of the situation where we could have had Shikshini Borough do this same thing, and they would have to, under the PUC code, secure a certificate of public convenience and be subject to every one of the protections that the PUC code provides to residents. And instead, by the mere act of taking that project and putting it into an authority, a municipal authority, somehow they're able to avoid complete oversight.
But that's why authorities are created, because the township's not in the business of running a water and sewer authority. So they create an authority and they staff it with experts. Those experts are the ones who basically have to run the system, so the township officials don't have to worry about regulatory compliance and all the rest of the issue. It goes to the authority.
I'm speaking, though, Your Honor, from a statutory construction perspective of the absurdity to believe that the General Assembly would somehow, just based on the nature of the form of the entity, completely eliminate protections to my residents in Conyngham Township for a very potentially catastrophic and dangerous public utility service. And that's what happened.
Well, that's not really what this is about. This is about, you were a member of this authority, or you had a contract.
We did have a contract.
Okay. You were a member of this authority, or you had a contract with this authority. You withdrew.
No.
You didn't?
They unilaterally terminated the agreement and began, and that's it. We had an agreement under D19,
right.
5607.
So they terminated it, but they're still somehow providing services in your municipality, and you want to stop them from doing that. It's not about they're providing them unsafely, or their rates are excessive, or any. Well, you had a contract with them, so presumably you felt.
So for breach of contract, or terminate the contract.
We would prefer, and our residents would prefer, to have the PUC, they're experts in regulatory oversight. We are not experts in that. They provided bulk service under D19 to our sewer authority in Conyngham Township. They unilaterally terminated the agreement, no successor agreement, and they began billing Conyngham Township residents directly. And really the only reason that my township itself, I believe, had standing to file the PUC action in the first place was because they billed us too. They build our municipal building. So we were a customer. So I can't imagine the General Assembly would have imagined that language in D9 would be intended to completely supplant the protections that are provided by the PUC.
But they're not, is what I'm trying to explain. Your client and the residents of your township have a contract to provide services. If you're not happy with those services, if somebody believes, if somebody starts putting on water and you're getting rust out of it or you're getting other problems, you're free to go out and basically terminate the contract, or better yet, get a water analysis done to see whether or not this is dangerous, there's dangerous lead levels or anything else, and sue the municipal authority in the Court of Common Pleas, not through the PUC, but it's a contractual matter. So you're free to go to the Court of Common Pleas if you think they're providing you services that are dangerous, that are problematic, that are not fair. Terminate the contract, go out and hire your own expert and sue them in the Court of Common Pleas as opposed to the PUC. All of the protections that you're talking about that the PUC exercises, you can exercise yourself.
It's a monopoly, Your Honor.
It's not a monopoly. You can go out and get another municipal authority and say, you know what, their rates and services are horrible. Would you guys be willing to compete against us? And we'll terminate the contract, and you can provide us with the goods and services. And that other company, whatever that company is, whether it's another municipal authority or another private municipal corporation, they're free to come out and give you an analysis and say, you know what, we want these 15,000 customers, and we're going to charge them X rate, and we'll make the connection rate, whatever the connection costs us, we'll make that back over our rates over the next 5 or 6 years in advertising.
We are directly connected to their system. So our options were to try to sue for some sort of breach of contract, or to require them to do what extraterritorial municipal authorities should be required to do, which is to secure a certificate of public convenience, be regulated by the Public Utility Commission, and provide our residents, our 200 residents, going out and getting...
Is that how many are, 200 on it?
I think we had 200 customers on their
That's
system.
efficient then.
So, again, this is a matter of, did the General Assembly intend that the Court of Common Pleas would somehow be, 6 to a half a dozen comparison to the type of oversight that the PUC provides? And it can't. It shouldn't, at least.
All right, any other questions? Thank you both very much. Well done. Would you call the next case, Mr. Minner? In this case, Appellant was charged with driving under the influence of alcohol. Appellant accepted the Commonwealth's offer to resolve her charge through accelerated rehabilitative disposition, or ARD. The trial court agreed to the ARD program and directed Worzel to comply with several requirements, including the court-imposed condition that she refrain from possessing and consuming alcohol during her period of ARD supervision. Around 2 weeks before the expiration of Worzel's 6-month supervisory period, she took a random drug test at the probation office, which revealed the presence of alcohol. She later admitted to having consumed alcohol. The Commonwealth moved to terminate ARD based on Worzel's violation of her condition not to consume alcohol. While the trial court determined that she did violate her ARD condition, it denied the motion, instead deciding to extend supervision for an additional 90-day period. Ultimately, the Superior Court affirmed the trial court's extension of Worzel's ARD, finding that the trial court properly acted within its discretion under the rules of criminal procedure when it decided not to terminate ARD. We are asked to address whether the General Assembly, through Section 3807 of the Vehicle Code, mandates the termination of ARD upon a court's finding that an individual violated a court-imposed condition of ARD for certain DUI offenses. Please proceed.
Thank you, Madam Chief Justice and Justices of the Supreme Court. Good afternoon. My name is Raymond Tonkin, and I'm the District Attorney of Pike County. I have no co-counsel with me here today, but I do have my son, Garrett, with me, who is interested in pursuing education in the law.
Excellent. Welcome.
You get the farthest travel badge for this.
Yes,
We
yes.
brought you all the way out to Pittsburgh.
Well, actually, I was hoping that I would be able to travel out here. I've argued in Harrisburg before this court, and I went to University of Pittsburgh Law School. My son just graduated from University of West Virginia, or West Virginia University, so he was able to come up here today. And I'm also able to see a law school classmate of mine, Rebecca Colissimo, who used to be Titus, who actually worked for the Chief Justice when you were in private practice when I was in law school with her. So
Wow, well, if you stick around long enough, you can see the NFL draft.
I'm going to get out of here before that chaos.
So has he applied? Has he applied to law school, or is he just considering that?
He just took the LSAT,
for him.
so I think 2 weeks ago. So he's waiting for that score in about a week or two, and then he's going to apply.
Well, we wish you luck.
Good luck.
Let's hope you don't blow this one, so your son, we hate to see your son become a doctor.
I think he has a good role model here. Go ahead, sir.
Thank you. Your Honors, the legislature, the General Assembly, has enacted 3807 to control DUI ARD cases here in the Commonwealth. With that, they've put out certain conditions that the legislature wanted to impose. They've allowed the Court of Common Pleas to impose additional conditions. Along with that, in 3807, they enacted subsection E2, which talks about violations of either A, failure to complete the legislative conditions, 2, being charged with a criminal offense under the Crimes Code, or violation of a condition imposed by the court. With that, the legislature has indicated if either of those three, here specifically a violation imposed by the court to refrain from the consumption of alcohol, that the Court of Common Pleas shall direct the attorney for the Commonwealth to proceed on the criminal charges under the rules of criminal procedure.
Can I ask you a question about that part, counsel? As you know very well, we're to strive to avoid finding a constitutional conflict or a separation of powers clash, right? Doesn't the legislature's placement of those words in the statute that they wrote as prescribed in the rules of criminal procedure tell us that they want the court to adjudicate versus purporting to tell the court what the result of its adjudication must be?
Well, I would suggest this, Your Honor. The legislature here has not told the court that there has to be a violation in this case. It's if the court finds a violation of the court-imposed conditions. Then with that, it just dictates not the procedure, how the court goes about that, or whether the court finds that. It just dictates what happens after that. So similarly, a court may adjudicate a case, a criminal case, that proceeds to sentencing. And the legislature can certainly indicate to the court you have to impose this punishment under a minimum mandatory sentence. I understand that may be a question now after Lee, but as the law stands now, it can dictate to the court what the court is to do upon to find a violation of the law, of a statute. So I suggest with that, I'd suggest we're not here for the constitutional issue here today. If this court reverses and sends it back to the Superior Court, that may be a question. But that would be my argument that that's why it would survive constitutional scrutiny.
Well, before we get there, don't we have to decide whether or not 3802 is according to what Justice Weck just asked you, is substantive or procedural? Does it create a substantive right on behalf of the defendant, or is it a procedural rule that this court has authority to recognize?
I'm sorry, Justice, you mean 3807?
Did I say 3802?
I thought so.
3807E2.
I'd suggest that the procedure of the violation is controlled by the Rules of Criminal Procedure under Section 318. We bring it to the court reviews it to determine if there's been a violation of the court order. So that's the procedure. It's just the substantive outcome after a finding of violation, I'd suggest that the legislature has directly controlled.
Okay. It seemed to me that the Superior Court's decision assumed that 3807E2 is a procedural statute.
Well, I suggest what the Superior Court did was they didn't really look at the text of it. What they said is, well, the operation of it in conjunction with the Rules of Criminal Procedure. They didn't really just look at the text and say, what does the text say? They just went right to the operation of the statute together with 318. And I understand that the Superior Court wrote this. It is not the Commonwealth's suggestion that DUI cases are not controlled by the Rules of Criminal Procedure to Section 300 chapter. My suggestion is that DUI cases, for one of the three here, if there's found to be a violation, the control is then you have to proceed. In other ARD cases, such as the ones that go through Pike County regularly, small amount of marijuana, retail theft, things of that nature, whether to remove the defendant from the ARD program is then, by 318, in the discretion of the trial court.
But you see no discretion in this situation.
In this situation, I'd suggest that the legislature has removed that. And
Can it remove it?
I'd suggest that it can. I'd suggest that the legislature can remove that discretion, just like it can remove the discretion to impose a minimum mandatory sentence. But it's not procedural. It didn't say this is how the court has to go about looking at the violation itself. It hasn't said this is the process. It hasn't said that the court has to find a violation. What the legislature said is if the court finds a violation, this is the outcome. Similar to if someone's found guilty of DUI, say a B or a C, either the court has to impose 48 hours imprisonment or 72 hours imprisonment. So it's outcome based, not how to go about it, not that there has to be that finding. So I see.
But why wouldn't we read it as the following way? We're told that the court shall direct the attorney, that's you, to proceed as prescribed in the rules, right? That's what the legislature said. And then we turn to the rules. And the rules say the judge may order when appropriate. And that's what happened here. He decided whether, and he ultimately decided it was appropriate to give her this, relief or whatever. Why isn't that the way to read it? Rather than, because the way you want us to read it, number one, sets up a potential constitutional conflict, separation of powers conflict, number one. And number two, it has a double disabling of discretion. It disables your discretion as the DA, disables it, takes it away, and it disables the court's discretion. Why would we go so far in our interpretive endeavors?
I would suggest, Justice Weck, in Jenkins, you authored a concurring opinion saying that 3807 is unambiguous. So, like in Jenkins, there wasn't a finding of a violation, so you can't remove somebody. Well, this is just the opposite end of that spectrum. If there is a finding of a violation, then you have to remove them. And I'd also suggest, more directly to your question, that phrase, to proceed under the Rules of Criminal Procedure. Remember where we are in ARD. The case is held in abeyance. Now, if there's a violation, it's to proceed forward.
Well, it's more than that. It's not just to proceed under the Rules of Criminal Procedure, which would seem to leave all of the panoply of what Justice Weck is talking about to evaluate keeping them in the program or not keeping it. It says to proceed on the charges. That language is specifically in there. I think the argument from the other side is probably stronger if it didn't say on the charges. If it just said proceed as prescribed under the Rules of Criminal Procedure, right?
I agree, Justice.
So, but I was going to raise Justice Weck's point. If we don't read it the way the Superior Court read it, you have no discretion. You must prosecute.
Well, we might have discretion to plea the case to something else. Under the rules of criminal procedure, we're proceeding under the...
Let's say they don't want to plead. Let's say, but you have no discretion. You either secure a plea or you can't drop the charges. You can't do anything other than proceed on the charges and get a conviction or a plea. You good with that? The DA's Association good with that?
I would suggest we would be, because under the rules of criminal procedure, we can eventually just move to dismiss a case or no pros the case and say, we don't think it has merit. I'd suggest...
Well, they wouldn't be an ARD if they didn't have merit, right?
Well, right, so if we get back to it, we have agreed to allow someone into ARD to not have to go through the process, either us or them. The cases that I handle regularly with ARD, we would otherwise prosecute them. And as many DAs around the state, and as this court has struggled with ARD litigation from Shiflett to Jenkins, and maybe now here to Worzel, it's kind of back and forth. You know, I didn't take the stand that some DAs did in Shiflett and ended ARD. I will tell you, after this case from the Superior Court and Shiflett, and it's been remedied now, I took a closer look at them to see, based on whether they should enter into it, but otherwise it would remove our discretion, and we're to proceed on the charges under the rules of criminal procedure.
Counsel, can I just ask if it makes a difference, or should make a difference in our analysis and interpretation here, that when 3807E was enacted, and it refers to as prescribed by the rules of criminal procedure, there was an extant rule of criminal procedure. In fact, the exact rule that we're talking about here that allowed the discretion of the trial court under these circumstances. Why wouldn't we assume that the legislature knew what the rules of criminal procedure prescribed when they enacted 3807?
Well, I would suggest that you would presume that they would know that, but that gets away, as I understand it, interpreting for statutory instruction, then that gets away if you find that the statute's not unambiguous, as I suggest has been referenced in the concurrence in Jenkins. Then we start looking at the nature of the statute and the reasons for it.
I'm not even doing that. I'm looking at a statute that uses the phrase as prescribed in the rules of criminal procedure. There was a prescribed procedure in the rules of criminal procedure when this was enacted that allowed the discretion that we're talking about here.
But,
I mean, I don't see it as a separation of powers issue or anything of that nature. I think it's just a question of looking at 3807 and the rules of criminal procedure at the time it was enacted and seeing that there was discretion afforded to the Court of Common Pleas.
That's correct by rule. I'd suggest
which the statute refers to.
Well, it refers generally to... It refers to the rules of criminal procedure generally, but as Justice Robson pointed out, to proceed on the charges. ARD, the charges are held in abeyance. So I'd suggest what the legislature said here is to proceed on the charges under the rules of criminal procedure. For example, in Pike County, regularly for ARDs, particularly DUIs, we do not file a criminal information as allowed by Rule 314. So we don't have to go the process of filing criminal information, having the person arraigned, and then allowing them to proceed under ARD. It shortens work on my staff. So to proceed on the charges, I'd suggest the legislature would mean then Commonwealth, go file the criminal information, the person gets arraigned, and then goes through an adjudication process.
You would agree that there would be a hearing?
Absolutely.
Okay, see, but that's exactly what 318 said at the time 3807 was enacted. Following your analysis, I don't find any fault with it. There's a failure to complete, maybe, and I'd like to talk to you about that a little bit, but there's a failure to complete, and then what happens? What then happens, the court shall direct to the Commonwealth to proceed on the charges as prescribed. You look at 318, it says, have a hearing. Court have a hearing, and the judge shall afford the opportunity to be heard, you would agree that would happen under any rule of procedure. This one just specifically goes on to say, and then if the judge finds there was a commission of the violation, the judge may order when appropriate. And then it goes on to completion. I don't see how this rule is inconsistent with any part of 3807.
I'd suggest, Your Honor, if you look at the rules of statutory construction, if we're saying that it may have some ambiguity in it, which I understand the Justice to be indicating, then we look at the occasion and necessity for the statute. So given the danger that drunk drivers pose,
I'm not suggesting there's an ambiguity.
Okay.
I think I'm suggesting the contrary. I mean, I'm suggesting what this statute tells a reader to do is look to the rules of criminal procedure.
And
I am looking at Rule 3318, which was enacted in 1972. This statute was enacted in 2001. Why do we need an ambiguity to look at Rule 318?
I'd suggest the statute was enacted, I believe, in 2003 and to take effect in 2004. However, I mean, this is the process, right? So we follow the 300 rules, 318. We file a petition or a motion to terminate. From there, the court determines whether there's a violation or not, or whether a failure to complete the program. Then I'd suggest, if there is a finding of violation or if the person's been charged, I listened to Jenkins again, and there was a lot in Jenkins about whether an individual had been arrested or charged. That was a distinction. Here the legislature says charge under Title 18 or violates one of their rules, then you shall proceed on the charges pursuant to the rules. I'd suggest your interpretation, Justice, would be it's not proceeding on the charges. The charges are in abeyance. You'd still be holding them in abeyance. It means that then there's no finding. There's no proceeding on the charges. Not, okay, we're going to hold them in abeyance. We're going to keep the charges in abeyance. That means you're not proceeding on the charges.
Let me ask you one other question, and I'm sure that you will know the answer to this. Does the court have the ability to modify the conditions of the sentence, so to speak, of the ARD? I mean, this is an odd situation because the admission to drinking alcohol occurred prior to the conclusion of the ARD. And so the trial court, at that point, if the ARD was not completed, the trial court decided that it was going to extend the term of the ARD. Is there a problem with that?
First, I'd suggest in this case, likely not, because it was counsel for Megan Worzel that asked for that.
And what would be wrong with that? Why do we, if we look at it that way, the ARD was not completed, we aren't looking at an ARD that had been terminated. She didn't serve the full term of it. The trial court looks at the situation where she admits she has a hearing and decides, I'm going to extend the term of the ARD. As long as the extension is not beyond the term that's permitted, why isn't that an appropriate thing for the court to do under these circumstances without triggering this notion as you are discussing it as needing at that point in time to immediately to proceed on the charges? Why can't he just extend it?
I would just suggest that was for the legislature to determine, and that's what they decided.
What about this situation that precludes the court from just extending the term? Because the term had not been completed. There were 2 weeks remaining on the term. Mm-hmm. At that juncture, is there something in the statute that precludes the court from saying, I'm going to give her 90 more days?
I would say that the statute requires that the court direct the Commonwealth to proceed on the charges and to move forward on those charges that were held in abeyance.
So it's a strict liability concept. she made that mistake and that's it.
Well, it's not a strict liability. That would be requiring the finding of a violation of strict liability. This is just a consequence. It's a strict consequence of
That's a
finding
better
the
way of
violation.
saying it.
Non-discretionary.
Yeah, that's a better way of
Yeah, but
saying
see,
it.
I think what you're setting up, though, and you have to realize you might be setting this up, which we could side with you, but a common pleas court judge hearing this exact scenario might go, I'm not violating her.
I'm not
In which-
finding a violation.
Well, I'm not violating her. And that's pretty much what you're setting up. We're going to have, which I guess isn't a problem. I mean, judges are going to decide, because we know what the consequence of a violation is. Even though you're presenting me with what is technically meets the definition of violation, I am not going to violate her, because if I do, I'm going to have to order you to proceed on the charges, and I don't want to do that. So I'm not going to violate her, but I'm going to tack on 90 additional days. And then the defendant's going to be, well, you can't do that because you're not violating me. Then the judge is going to go, okay, I'll violate you, and then you have to go on the charges. That's the follow-through of your position here.
Well, I understand, but there may be another follow-through. In other words, let's say the statute says we should have proceeded on the charges. Now, another 90 days, and it's not here, but looking into the future, Justice, now there's another violation. And then the defendant comes in and says, well, Judge, you couldn't have continued this. You should have done this a long time ago. Now I'm out. Now we're outside the original 6 months. Now you can't do anything. And then
I'm not sure I'm following your. I'm not sure I'm following your hypo. I guess all I'm saying is I'm wondering whether this really is that big of a deal. Because unlike Shiflet, there's really no workaround. We needed a legislative workaround. But the workaround here, which seems to be within the authority of the courts, because you agree that whether to find a violation is purely discretionary, if we issue the decision you issued, nothing's going to change. Judges are just going to be more careful about finding violations where they think it's sort of a nominal or de minimis situation.
Well, perhaps they will.
You can't appeal that.
Perhaps they will. Well, I mean, we could talk about that a little bit, right? Because we might say then they didn't successfully complete. And that's really...
Well, that's going to be up to the judge.
Well, that may be later on. Do you see what I mean? And that may be an argument whether they successfully completed it. But I guess I'll try to state it clear. Take, for instance, Ms. Worzel, 6 months. She's granted ARD for 6 months. The judge says, you know what? I'm not going to find a violation, okay? But I'm extending it for another 30 days or 90 days. Well, then, can the judge even do that without the finding of a violation? Because there was 6 months, could have been given 12 at the beginning, but says, you know what, I'm not going to find any violation, but I'm going to move it out.
And isn't that inherent in trial court discretion to do that?
No, if I may,
Surely.
my complete argument is it's not at this point if there's a finding of a violation. But then a defendant could come in and say, you know what? You didn't find a violation. You had no authority to extend this because your original order was 6 months.
Yeah, but see, that's not what's going to happen under my hypothetical. Under my hypothetical, the common pleas court judge is going to have the defendant there, and the common pleas court judge is going to be like, look, if I find a violation here, these charges are moving forward. The other option here is for you to agree to stay in this program for 3 months, waive any challenge you have to that, and I will not find a violation, and put that all on the record.
And I'd suggest, even as the Superior Court suggests, this is a work together with the Commonwealth, because we originally moved. And that's part of the concern here is we moved the defendant into ARD, right? They have ARD. There's a violation of ARD. Now all of a sudden we're out of it. It's completely up to the courts. It starts kind of as a partnership suggested by the Superior Court, and then all of a sudden we're out of it.
But aren't you out of it normally once ARD kicks in? What role does the prosecutor play once a defendant is placed in ARD?
Bringing to the court attention of violations.
So, counsel, permit me. In this particular case, what you're asking us is an application of strict liability. And what it's also doing is deferring the honesty of a defendant should the defendant choose to be honest to the court. That being, hypothetically, the order I order, you're not allowed to drink alcohol. The client that's standing in front of me is under my ARD watch because he has a chronic, severe alcoholic. He comes in because there's a violation. During the course of the violation, I say, hey, Mr. Smith, did you drink alcohol? And he said, Judge Doc, you've been around me a long time. I'm an alcoholic. My son killed himself. And yes, I got drunk. And he says, but the services you provided me are incredibly helpful. But now I need some counseling for grief. Can you give me grief counseling? Under that fact scenario, with your interpretation of the law, I have no choice but to force you to prosecute him. Is that what you're saying? And if so, how does that not fly in the face of judicial discretion?
I'd say two things, Justice. I would say it's not strict liability in terms of there still has to be a finding of a violation.
I find that there's a violation. He said it. I drank, Doc.
And so then I'd suggest that's correct. That's what the legislature wanted in DUI cases. They didn't do it in retail theft. They didn't do it in marijuana cases. But DUI cases, because of the, I'd suggest, the nature and danger that drunk drivers pose to the motoring public, that the legislature could look and say, you know what, we're giving you this chance through ARD. Abide by the rules, and everybody goes home happy, because it'll be expunged, you won't have a record, you won't have to go to jail, you won't have to be under stricter supervisions of conditions of probation, even if it's a sentence of probation with restrictive conditions. I'd suggest that the legislature, that's what they wrote in the statute. I understand, but that really suggests that the statute is ambiguous, and then getting to the reasons of it, which is what the Superior Court did.
We interpret the statute as being absurd. The concept of ARD is rehabilitative. The facts before the court is that a person is in need of rehabilitation and requesting additional treatment.
And
that flies in the face of the concept of ARD, but you're putting words of a statute over the General Assembly's policy that we can provide diversionary programs to assist as opposed to hurt.
The person's already attempted to be diverted. That's what has happened. They've attempted to be diverted.
One chance only, right? That's the way you're interpreting it, as one shot only.
For those certain things, if there's a finding of a violation, I'd suggest that. I mean, you know, when does it end of, if they haven't gone to alcohol highway safety school, that's one of the conditions. If they haven't done that, like when does it end in terms of they haven't availed themselves of rehabilitation? Do you see what I mean? And they say, well, I haven't gotten there, but I want to, and I'm going to continue my rehabilitation. Well, when does that end?
Well, one has to take into consideration the extent of the individual being on ARD, the application or the compliance with the ARD conditions, and I guess the discretion of the judge. That's the whole concept of sentencing.
It ends when the judge says it ends, and 90 times out of 100, you're going to win that.
Maybe yes, maybe no. And I'd suggest to Justice Robson's earlier question, in terms of, well, judges aren't going to find a violation. I mean, if DAs know that it's always going to be up to the judge and somebody can come in with a story, right? And again, we're not talking about small amount of marijuana. We're not talking about retail theft. We're talking about somebody that poses a danger on the highways, right? DAs may be more reluctant to even move somebody in, right? To look at it and say, you know what? They had an underage drinking 9 years ago. I'm not so sure. They had an alcohol problem before. I'd suggest in that I'm probably not abusing my discretion if I don't move, because I think, I'm going to give them this shot. And if they're good, they're good. But maybe I won't give them the shot because I know, well, then it's just up to the judge.
Well, it is your call. It is your call whether to do it or not.
Sure, but it just like...
Does Pike County have a DUI court?
No. We don't have a drug court either. But what I would suggest...
But that would be separate from... So for somebody who has a chronic encounter with law enforcement for DUI activities, that would be something beyond ARD that a county, if they had a DUI court, could provide.
Yes, and
not subject to these restrictions, which can seem to some to be draconian. A court-run DUI program could provide that continued support if a court had one.
That's correct, and I would suggest, while we don't have a DUI court, what we do have is what's called PICARE, and it's the Criminal Addiction Response Effort. That's where many second offense DUIs go. That is really probation with restrictive conditions. We use SoberLink a lot to monitor them in that program, really to deter them from drinking and to monitor their drinking ability. So it's not a court where they appear all the time, but there's an effort they have to be employed similar to that nature. It's really just monitored more closely by the probation office for a period of time rather than appearing in court. So there has been attempts at that. It's just not a DUI.
Not a treatment court per se.
That's correct.
Mr. District Attorney, I think we understand your position. Let's hear from Mr. McIntyre.
Good afternoon, Madam Chief Justice. Good afternoon, Associate Justices. Thank you for the opportunity to be here today. My name is Nicholas J. McIntyre. I am partner for Oliger and McIntyre, located in Milford, Pennsylvania, and I've had the pleasure of representing Ms. Worzel throughout this process. The question before your honors today is whether 3807 is ambiguous. I would suggest that it is not.
Let me stop you there. This is where Justice Weck was going earlier, and I really didn't get an answer to it. The Superior Court only got to their decision by employing the doctrine of constitutional avoidance, correct?
I would not say that's the only reason they got there, but that was a sticking point, I think, ultimately, in swinging their decision towards.
Before they even get to the issues, the interplay of Rule 318 with 3807, there was a constitutional question. And the only way you get there is through the application of the constitutional avoidance doctrine, which is what the Superior Court applied in this particular case. I've now heard 4 justices, the DA of Pike County, and yourself stand up and say, there's nothing really ambiguous about 3807. So if there's nothing ambiguous about 3807, did the Superior Court err in applying the doctrine of constitutional avoidance? Because you can only apply it where the statute in question is susceptible to more than 1 or 2 meanings.
I respectfully do think the Superior Court erred in finding the 3807 to be ambiguous. I think it's very clear in its incorporation of the Rules of Criminal Procedure.
Well, if the constitutional avoidance canon is not applicable, how is it possible for you to win?
Because following 3807E to its T,
What if it's unconstitutional?
if 3807 is unconstitutional,
You all just said it's not ambiguous. Therefore, shouldn't the question be addressed? The first question is whether or not it's constitutional.
I don't believe it is constitutional because it challenges.
Nobody's answered that question, which is my point. Justice Weck had raised that in his dissent beforehand, or his opinion about the ambiguity of the statute. By my reading, and I understand we didn't grant aliquotter on the constitutional question because the Superior Court avoided it by applying the canon. But we're now all suggesting that 3807 is not ambiguous. So the first question needs to be answered before we even get into the interplay of these and whether or not 3807 and Rule 318 is substantive or procedural, create substances or procedural rights, is whether or not it's constitutional.
And Justice McCaffrey, I would suggest that it's not, and I think it goes further back than just Chapter 3. If you look at the Rules of Criminal Procedure,
I might agree with you, but we haven't.
Rule 100 and Rule 101, Rule 100 and Rule 101 set forth the purpose and applicability and construction of the criminal rules. And then within 101, it references the judicial rules. And 115 specifically notes that any law, any legislative law in conflict with the rules is invalid. So my argument would be that 3807E2 specifically, that portion of the statute is unconstitutional. Under that, I still believe the trial court proceeded exactly as it was supposed to. Under Chapter Rule 3, which is 318, there was a violation of the condition. It was brought before the court. There was a violation hearing that was had.
But the rule, the problem is the statute doesn't say proceed to adjudicate. It doesn't say proceed under the rules. It says proceed with the charges under the rules. And it's, to me, I'm struggling with the proceed with charges language, not so much the general rules reference. Do you believe every rule in the Rules of Criminal Procedure relates to how a court proceeds with charges?
No, I believe that when that Rule 3807E2 directs the district attorney to proceed with the charges, and the district...
Directs the court to direct them to proceed with
Yeah, and then the district attorney does by filing the violation under 318. I think, my argument...
not the order. This section specifically deals with the violation. This section says what happens after the hearing on the violation. This is not about the hearing on the violation. The rules seem to be consistent with the statute on that. Where the inconsistency is our rule on the hearing says that the trial court has discretion after finding a violation to direct the district attorney to move forward. This statute says after the hearing and the decision of a violation, the trial court shall direct. There's no discretionary language in the statute.
And I think my argument is the trial court directing the district attorney to proceed on the charges means the district attorney then files the violation under 318.
This is after the violation. It says proceed on the charges, not the violation. Proceed on the charges.
And as it relates to the specific language used by the General Assembly, if their intention was to divest the trial court of the rule, of the powers vested in it and the discretion vested in it by 318, I would argue the General Assembly needs to be more specific, and I think there is superior case law that would support that.
But you read out proceed on the charges. Your reading reads out proceed on the charges.
I don't understand.
If you look at the statutory language, it says the court shall direct the attorney for the Commonwealth to proceed on the charges as prescribed in the Rules of Criminal Procedure. Your reading is the court shall direct the attorney for the Commonwealth to proceed as prescribed in the Rules of Criminal Procedure. You read out the phrase on the charges. That's your reading.
As it relates to 3807,
yes.
Correct?
Yeah, but we have to give meaning to every single word in the statute. Whether that results in a constitutional issue, I don't know. I haven't looked at that, but I'm just trying to understand what the statute means. And what do you mean? What do you think the General Assembly said when it said to proceed on the charges as prescribed by the rules?
I believe their intention was for them to file the violation under Criminal Rule 318, and I understand the court's position that has come after the violation was found. But respectfully to the General Assembly, I think that is a mistake that was made without fully considering the breadth of Chapter 3 as it applies to the ARD program.
Well, counsel, in sub I under 3807-2, you see the word fails, correct?
Yes.
Doesn't that word fails tie into Rule 318 where the judge may order? So the judge has to determine if there's been a failure, and then if there's been a failure, may order. Isn't that a way to reconcile this language?
I think that's a fair interpretation and a way to reconcile the
Contrary to
language.
your position on ambiguity, if we judge this to be ambiguous, then the constitutional avoidance doctrine could tip this court in that interpretive direction, correct?
Yes, Your Honor. I think that there are two approaches that I would take to this case from the appellee perspective. The first is my argument is that we went on the plain language because it expressly incorporates the rules of criminal procedure, and the trial court followed them to a T. That's the first argument. If Your Honors are not inclined to adopt that argument, and we do turn to the ambiguity test, as the Superior Court reflects in their very well thought out opinion, I think that the ambiguity test falls in the appellee's favor as well.
Counsel, what happened in this case? I know that there was a random drug testing. Then what happened?
There was a violation notice that was issued.
Okay.
Ms. Worzel attended.
Violation notice.
A violation notice.
But no finding of a violation of a notice.
No violation. And then there was a violation hearing scheduled before the trial court. My partner, Attorney Oliger, covered that for our firm.
Was that a 318 hearing?
I do not recall.
Well, I'm trying
I would have to refresh my
When
memory.
was there a determination that there was a violation here? I mean, as I was trying to digest this, it appeared to me there was one hearing, and it was a 318 hearing.
My understanding of what occurred that day is that it was a two-part hearing. There was a finding of violation, and then there was the imposition of sanctions. As is consistent with violation of probation hearings, not just in ARD, but in the criminal practice.
Should we glean anything from the fact that this language is different from the other ARD?
It's a question that I struggled with in preparing for the hearing today. Where I ultimately land on it is the history of the ARD program. In 1972, this honorable court created the ARD program, and it was for the purpose of addressing crimes, quote unquote, that had social implications and geared towards rehabilitation. Then in 1982, there was a directive from this court to the legislature permitting the legislature or directing the legislature to put forth rules and statutes as it related specifically to DUI. When this court did that in 1982, I don't think the intention was to totally divest itself of hearing probation violations as it related to ARD DUIs. For a court to divest another court of its discretion, especially a court of common pleas judge, I think would be an extreme result. As was indicated before, I think the further extreme result would be divesting the prosecutor of all the discretion that comes with prosecuting cases simply because of a strict liability interpretation of a violation alleged under 3807E2. 3807E2 is, from a reasonableness interpretation, from a common sense interpretation, is directing how the failures under that section are to proceed. If 3807E2 wanted to create the harsh, draconian, strict liability consequence, the Superior Court case of Prince requires, or would suggest it requires, the General Assembly to be more specific in divesting that power from the trial court. Whereas this conflation of the word shall versus proceed on charges, I don't think is precise and clear. I understand that there's an interpretation that you can make that would then significantly entirely curb the trial court's discretion under violations on ARD DUIs. But if that was the case, the Superior Court case law that addresses this issue, Ayers, McCabe, which reinforces the idea that Rule 3, or excuse me, the legislature doesn't get to overrule Rule 3. The rules that the legislature puts forth as it relates to ARD need to comply and be in conformity with Chapter 3. So the Superior Court case law that supports that, I think, is very strong.
Well, we understand the issue, and we're going to sort it out. I thank you, Mr. McIntyre, and thank you, District Attorney Tonkin. What is your son's first name, sir? Garrett? Garrett, I sincerely hope you'll follow in your father's footsteps and head to law school. Thank you for being here. Yes.
You saw a really good argument today, Garrett.
Very, very good.
Yeah, did a good job.
This concludes our spring argument session in Pittsburgh. I would like to thank PCN for videoing and broadcasting our sessions for the purpose of public education. I'd like to thank our court crier, Brian Minner, and our prothonotary, Caitlin Gorman, as well as our court judicial security, John Evans, Gary Shovlin, and Scott Town, as well as the Pittsburgh City Police and the Allegheny County Sheriff's Office for providing protection during court proceedings. Mr. Minner, you may adjourn the court.